Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, chair of the board. The board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malice, and Peter Owen. Paul Melnick will be absent tonight. Also present is a professional staff, including Stephen Rissy, coordinator for the BZA, Arlo Vavon, zoning administrator, Cliff Hogan, assistant to the zoning administrator, Simon Keynes, administrative technician, and Christine Sanders, representing county attorney. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask you please turn off your cell phones or pagers or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination, or direct questioning by others. We have deemed the following time limits for speakers to be sufficient: 20 minutes for appellants in appeals, 5 minutes for applicants for use permits and variances. For use permits and variances, we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case number V-11195-16-UP1 is a use permit request by Yogi Demara, owner, to permit a setback of 25.4 feet to the wall from the rear property line instead of 25 feet as required, 8.3 feet to the wall from the left side property line instead of 16 feet as required, and 11.4 feet to the wall from the right side property line instead of 20 feet as required for a bed and breakfast, and in the R6 zoning district, premise known as 3120 North Pershing Drive. The application has been withdrawn by the applicant. Therefore, staff recommends that the board adopt the motion to withdraw the subject use permit request.
Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals withdraw the use permit case V-11195-16-UP-1.
Second.
Moved by Mr. Owen, seconded by Mr. Smith to withdraw. All those in favor? Aye. Thank you. Next case, please.
Case number V-10226-17-UP-2 is a use permit request by James and Rachel Hensler, owners, to permit a setback of 14 feet to the wall, 13 feet to the eave, from the right side property line instead of 25 feet to the wall, 21 feet to the eave as required, for the expansion of an existing screen porch with a new second-story right side addition in the R8 zoning district, premise known as 1422 North Jefferson Street. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions.
Questions for staff? We hear from the applicant, please.
Good evening. We're Rachel and Jim Hensler, back for a third time. Let's hope third time's a charm. The first meeting that we attended with you all in June, we listened very carefully to the concerns that you raised, and then we went and did some more homework and worked with staff. Who's been great, very, very impressive. You will see in your packets that we have some photos, just of a few of the number of two-story additions in our neighborhood. We also did surveys of a number of properties in our neighborhood to find ones that were closer to the curb than the 25-foot setback, and we found a number of them. Then we sat down with staff and came to an agreement where instead of asking for 3 feet out, we would only ask for 2. And that way we would no longer be an outlier in the neighborhood. You all have a copy of our petition this time. I don't think you all had it last time. So we have significant neighborhood support. Actually, at the last meeting, we had a neighbor who was coming to speak in our favor, but obviously we didn't get to have her speak, so she couldn't come tonight. We've not heard of any opposition from our neighbors. No one's come to speak against us. And we just hope that the board will be willing to adopt the staff recommendation as we have come to an agreement, as we've modified it.
Thank you. Questions for the applicant?
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals adapt the attached proposed resolution approving the use permit in V-10226-17-UP2, subject to the conditions that are listed, of course, in the staff report.
Moved by Mr. Smith, seconded by Mr. Owen for approval with conditions.
Sorry, I didn't have my microphone on. I second the motion, but I wanted to check one thing. Does this have the condition about not being built over or enclosed?
It's 2 stories, isn't it?
They are enclosing it and they're building a second story.
Oh, I see.
on it.
That's the whole
So-
point of the application. Got it. Okay, sorry. Thanks. Yep.
Okay. All those in favor? Aye. Thank you. Next case, please.
Case number V-11238-17-VA-1 is a variance request by Douglas Marshall, the owner, to permit a main building footprint of 35.7% and a total lot coverage of 47.9% regarding a 2-story addition with attached garage in the R8 zoning district, premise known as 6100 31st Street North. Staff recommends that the board defer the case to the October 18th Wednesday meeting so that we could actually hear both of the requests at the same time.
Okay. Comments, questions, motions?
I'd wonder if there are any folk here supposed to speak on the matter.
Simon, do we have any speakers? No, no speakers. Okay, thank you.
Madam Chair, and I assume the applicant
Well, the applicant's attorney is here.
is satisfied with the Wednesday hearing.
That was their original request, so I can't think that that's an issue.
Just
Is that correct, Mr. Lawson?
I was asking if the applicant agreed to the deferral to Wednesday.
The applicant,
Agreed to the deferral
yes,
to
ma'am,
Wednesday.
the applicant requested it. We have another architect taking a look at it, see if we come up with a better plan.
And you'll have
Is
that on Wednesday?
You're going to have that on Wednesday?
No, we wanted to defer it to November.
Well, this is a deferral to Wednesday, this October.
Okay, well then we would want to move it to November if we could.
You are on the agenda for Wednesday as well, given the unusual snafu of our meetings.
Yeah, we won't be ready on Wednesday.
Okay, so staff, what do you suggest?
As a preview for Wednesday, the staff is actually recommending that the application be deferred until December, since the zoning notifications for November will need to go out. So on Wednesday, we'll be asking for both of the applications to be deferred until December. You could certainly defer this application at this time to December,
Or
but
February?
or February, or whenever you care.
Is there any reason to go through this again on Wednesday?
Well, I'm trying to get rid of Wednesday. Are we allowed to do that? Or just, Madam Attorney or Madam Zoning Administrator?
You can't act on the item that was advertised for Wednesday. You can certainly defer this one to December, and we'll have to do the subsequent action 2 days from now for the related case.
Okay, that works for me. Can I have a motion
Thank you.
to that effect?
So we're deferring this to Wednesday?
Just the variance.
Well, Madam Chair, I think that we can defer this matter to December, and then on Wednesday, defer the Wednesday matter to December in consort with what the staff is asking. I think that kind of accomplishes both.
Okay, I have made,
And Mr. Lawson may not have clearly understood really what was before us when he came up.
right. Can I have a motion, please?
Madam Chair, I've moved to defer V-11238-17-VA1 to the December meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Ms. Malice to defer this variance request to the December meeting. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V11279-17-UP1 is a use permit request by Thomas R. Mewborn to permit a setback of 1.1 feet to the wall and 0.1 feet to the eave from the rear and right side property lines instead of 10 feet as required regarding an existing 2-story accessory building in the R6 zoning district premise known as 1704 South Lincoln Street. Staff recommends that the board adopt the attached resolution granting the use permit with conditions.
Questions for staff?
Sure.
Mr. Moon?
We had a neighbor, the rear neighbor, come testify at a previous consideration of this item in opposition. And I think we've since gotten a letter from that neighbor saying that they're apparently withdrawing their opposition because of an understanding they have with the applicant to put screening in between the structure and the property line that they share. Am I correctly understanding the situation?
That is my understanding.
Does staff have copies of or any information that specifies the nature of the screening that's proposed?
We do not.
Okay. Thanks.
We do have a speaker from the house behind. Mr. Mewborn.
Good evening. Well, the conclusion of the last hearing on July 20th, it seemed the one issue in the way of our getting permission to continue building the garage or remodeling it was the brand's opposition to it in the first place. And your suggestion was that we meet with them and try to work something out that was mutually acceptable, which we did on August 13th. We went over and, because I'm an artist, I did some architectural drawings, proposals of various things that could be done to minimize the effect visually of our garage to their view from their backyard. And they seemed to be okay with that. They thought about it for a few days, and then they let me know that they would be okay with that. I also offered to pay for all of the landscaping that we had proposed, so I think I made a fairly generous offer to try to get their agreement, and so they did comply with what I asked them to do, which was to withdraw their opposition in an email, and also to come and speak to that effect. And I have a copy of that.
Thank you.
Thanks.
David and Melissa's email stating that. And I pointed out to them that the color scheme, which I think I mentioned the last time I was here and spoke, is such that it tends to minimize the mass of the building. The roof blends in with the trees. The siding is very light. So, I mean, if you look at the siding, it's almost the color of the sky if the sky didn't have a lot of blue in it, which would be the case on the horizon. So, I mean, I did give a lot of thought to that from the very beginning. And so I pointed that out because I'm an artist. I think visually, and not everybody does, so I wasn't sure if they had visualized that or not. So we talked about that some. The other thing that I mentioned to them that has nothing to do with my garage really was that if we were to put some type of screening plants in their backyard along the fence that backs up to our garage, it would not only minimize the visual appearance of the garage, but it would absorb the noise from Monroe Street, and there are a lot of trucks and buses and things that go by. The foliage there is going to act as a sound absorber, so really, I mean, I think they're going to get double their money's worth, if you want to put it that way. So I believe that this is satisfactory, and I believe that they're here to speak to that effect. So thank you for your time.
You're welcome. Any questions for the applicant?
So if I understand the proposal, the landscaping will be all on the other side of the fence,
Right,
not on your property?
right.
Okay. And you have drawings that you've shown the,
I didn't bring them with me, but I do have drawings.
and do they have drawings?
Yes.
They have a copy of the drawings, okay.
Madam Chair,
They have
Sure.
drawings and a signed agreement, so I mean, it's in effect an informal contract, so.
Mr. Owen?
Just looking at the letter you just a moment ago handed to us, it looks like maybe they are the ones who are going to do the landscaping, but you're offering to pay for it. Is that right?
They wanted to have someone they've done business with before actually do the landscaping. I offered to do all of it, but that's fine with me. I said, okay, that's fine. You get your person to do it, and I'll pay for it, so.
But they're going to direct how it's done.
Yes.
Okay. Thank you.
Other questions?
Just to clarify, the plan that you presented to them, is that a landscape plan, or is that simply the facade of your building?
I took the elevation view of the rear of the garage, and I drew their fence in and the tree that's in their yard, and then I sketched in a couple of different scenarios of plantings and how that would look if it was done.
Yeah. So it's a landscape, it was a landscape plan or a landscape rendering. Okay. Thank you for working with the neighbors on this.
Okay.
I'll probably have one question for you after your neighbors speak.
Okay.
Thank you.
Thank you. We have one speaker, Melissa Barron.
Hi. As Mr. Mewborn stated, we reached an agreement that we will withdraw our opposition to the zoning variance application on the condition that they provide monetary assistance for additional landscaping to attempt to obscure the building. While this is not the situation we were looking for, it was abundantly clear that no altercations to the building were going to be made. And so while our desire would have been for our neighbors to build within the zoning ordinance, it became apparent that that would have been impossible without our further investment and maybe even potentially legal expenses. So while we did not issue this building permit, nor did we start construction, we felt like we were tossed into this situation. And yet the burden was placed on us to resolve it. And we had to come up with a choice to rely on the board or try to potentially get the property value of our property back to where it was potentially. And I asked you guys that in the future, if the county makes a mistake, I hope that they take responsibility for the mistake. And when given the clear facts and implications that these mistakes have on the neighbors, please do not push the burden onto them. These were people that these rules and regulations are meant to protect. So I beg you to please consider that moving forward. Thank you.
Thank you. Other questions or comments? That's the only speaker.
Madam Chair, if there's no questions for the speaker, I would have a question again for Mr. Mewborn.
Mr. Mewborn.
Thank you, Mr. Mewborn. So your letter of agreement included a request that your neighbor speak in support of your application, which she's now done. Do you feel like at this time your neighbor has fulfilled her obligations per your agreement?
Well, the ultimate goal here was to get the use permit, and that was that's what our help to them for their landscaping hinges on. So
if you get
done her share, now I'm hoping that you'll round that out.
But you don't feel she needs to do anything more to fulfill what you asked her to do in the letter?
Not unless you want to vote against me, then I would say that it didn't work and it wasn't satisfactory.
Okay.
As I said, it hinged on getting the use permit. And let me just reiterate again, I've already spent all the money I have to get this garage to the point that it's at. I've lost a tremendous amount of stuff that I had stored in the garage from sitting in the weather. Building materials have had to be thrown out. So I'm way in the hole now. I can't go forward without the use permit. I can't go backwards because I don't have the money. So I'm in a tough spot. Like Melissa said, we're both in a spot we'd rather not be in. So we're looking to you for some help now to let us get on with our lives and not, not have to deal with this any longer.
Thank you.
Any other questions? Okay.
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in case 11279-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Mr. Smith has moved for approval, seconded by Ms. Malice. I will not support the motion. I will not be the one who sabotages it, I assume. But this case has really bothered me from the very beginning. I agree with the speaker that the county has a responsibility, having issued a building permit in error. While I agree that probably because they had no choice, they've now chosen to support it, the application. I think everybody loses in this situation, but most of all, I'm frankly more sympathetic to the people who have this in their backyard, and that's very disappointing to me. So I think there probably is sufficient support for the motion, but I wanted just to express my frustration that the county issued a building permit in error, and none of us would have had to deal with this issue had that not been the case. Are we ready to vote?
Madam Chair.
Mr. Owen.
I wasn't sure how I was going to vote on this, and then your speech made me even less sure.
Oops.
I think at this point, dragging this out further when I have the sense that both of the neighbors have been working for months and months on trying to get a resolution is probably not the right answer. But I did not expect to find myself in a position of voting in favor of this application at any time. I do not think that we are responsible for addressing errors that other parts of the county make. And I think to my mind, I don't think that the application makes a good case for meeting the statutory criteria. So as you were speaking, I was toying with the idea of voting no, and then we'd be split 2-2, and then
Well, we haven't voted yet.
move to reconsider and all that kind of stuff. So I just feel like there's a rule that if a body like us doesn't have a majority for something, for anything, and we're just totally deadlocked, that it's appropriate for one member of the body to give a pro forma vote in order to just get the resolution. And so I think that because we have 4 people tonight, I'm going to vote yes on the motion, even though if we had 5 people, I would have voted no.
Thank you. Anybody else?
Clearly the county made a mistake. It's obviously not the first time. We've heard cases like this before, where a use permit has been granted by the county and then zoning comes in and says after the fact that it is an error. And we have to weigh, considerable financial cost to the applicant who received a building permit legally, and he was legally entitled to build the structure, and only to find out that another branch of the county says it's not legal. We did ask the two parties to go back and talk to each other because that was the best way that possibly there would be relief among the neighbors. You know, I understand it was very reluctant, but I hope that, you know, we can move on. But to ask the applicant to tear this down would also have been a large hardship. So I don't know if there's a track record on which way we vote on these things. You know, do we tell them to tear the building down, or do we ask the forgiveness, basically, of the neighbor? I think that's what it comes down to, is the county is asking the neighbor's forgiveness for an error. There's, to Ms. Barron's comments, there's nothing that we can do to fix this. You know, once it comes to us, it's already done. We wish we could. We wish there was something in our power that we could prevent this from happening in the future, but it comes to us as a matter of last resort because the county finds itself where it is. I will support the application because I hope that the parties will be able to live together and get past this, but that's my reasoning.
Thank you. I think in the end, everybody is compromising admirably, but I still think that the cause of the whole issue was the building permit, and it seems to me that whoever did that is kind of getting away with it. But anyway, let's move on. We have a motion on the floor. All those in favor?
Aye.
Opposed? No. 3-1. Thank you. Next case, please.
Case number V-11289-17-APP-1 is an appeal by the Westover Market and Beer House and George H. Rucker Company, LLC, the owner and landlord, of a violation notice issued for violating the conditions of a special exception use permit U-3297-11-1 in a C1 zoning district, premise known as 5863 Washington Boulevard. Staff recommends that the board make the findings in the attached resolution and uphold the determinations of the April 26, 2017 violation notice and the May 5, 2017 amended corrective action for the violation notice issued by the zoning administrator stating that the appellant's use of the outdoor cafe at the subject property is not compliant with the conditions of use permit U-3297-11-1. Please note that there is some supplemental material for this case that came in after the application packet was assembled and printed.
Questions for staff? Applicant? I have a speaker slip for Skylar Aarons. Is that somebody who's speaking in lieu of you, Mr. Lawson? Or sharing your 20 minutes? Or however you want to do it?
He's got the wrong case.
Oh, you do?
I'm sharing a different one. I apologize.
Okie dokie. Thank you. Mr. Lawson.
Madam Chairman, we're asking that this be deferred to the November meeting, and the reason for that is that the use permit that the county board granted requires that live entertainment cease at the end of October, and at that time there's no need for the magnitude of seating, and they would go ahead and do exactly as the county is asking. So we would ask that you all defer this to the November hearing because this will all go away on November 1 anyway. Mr. Hicks is here, and he's going to nod and say that, yes, that's his agreement, that they'll do that on November 1. So if you could, let me know if that's acceptable or not first. It might save us from having to do the whole case.
Questions from Mr. Lawson?
Is the question whether we're going to hear it tonight?
Well, yes, the staff has made one recommendation.
Yeah,
And
staff has not agreed to my request for the deferral.
yeah, the applicant's asking for a deferral, so that needs to be discussed.
If we don't grant a deferral, we're going to hear this tonight.
Yes, ma'am.
Okay. I fail to see your reasoning. The restaurant is in violation.
Alleged to be in violation.
I don't know if that's a question of fact that is.
That's the question before us tonight, if we have a hearing.
And the zoning administrator has ruled that you are in violation. We're being asked to decide whether we agree or disagree with her ruling. I don't see where the timing of that enters into it.
Because on November 1, the whole issue becomes moot.
May I? Madam Chair?
Mr. Owen?
I think I share the confusion of Ms. Malice, which is a violation. I got, if I get pulled over for speeding and then I later sell my car, I did not speed just because I'm not going to drive again. So I don't think I see why.
But if you have +5, the court will dismiss it.
See. So I'm not inclined to defer.
Can we have a comment from the attorney?
This is a decision for the board. I think the zoning administrator's position is clear. This stems from a violation, from complaints and violations that go back to April. I believe, to our knowledge, there haven't been additional violations of the live entertainment outside the permitted hours, but as the board can see, what could have easily been remedied, which is the removal of the seats that have not been permitted, they're still there. So that's the situation as it stands.
Question for the attorney?
Go ahead.
So even if the seats had been removed subsequent to April, there still would have been a violation.
We would submit that's the case, but certainly our goal generally is compliance with what the board has authorized. This is a use permit that the county board authorized in 2011, and so that's the point of this particular notice of violation, is to continue to support the conditions that the board placed on this particular use permit.
Other questions?
So, Madam Chair,
Mr. Smith?
No, I guess it may come out during the hearing. It has to do with, well, maybe I can ask the Assistant County Attorney, that it's the county's position today that the additional 21 seats are still in place.
To our knowledge, that's the case, yeah. I believe there was a zoning inspector that was out either today or this week, yeah. I mean, compliance is really easy here.
Thank you.
That's typically the goal.
Okay, let's proceed, Mr. Lawson.
Okay, thank you, Madam Chairman. The second thing I want to make sure is that right after the violation notice, we went immediately into compliance on the piped music and the complaint about the loudness. And so as far as I understand, the only issue tonight is the number of seats. And I just want to confirm that with zoning.
The notice of violation stems from a complaint of April 14th. So whatever happened on April 14th happened, and that's up for you all to decide. The notice of violation for the live entertainment outside of those permitted hours occurred on that date.
Madam Chair?
Ms. Malice?
Mr. Lawson?
Yes.
The issue, as I understand it, is that the zoning administrator upheld the April complaint. And therefore, our issue is whether we agree that the zoning administrator was correct in upholding the April complaint, regardless of what happened after that.
Yes, ma'am. I don't agree with that. The violation notice says you are directed to correct the violations by the compliance deadline indicated, which was done.
Okay, on the noise.
On the noise and the pipe music. So I think the only issue is
And the seats.
seating.
And the seats.
Okay, so you complied with 2 of the 3 issues.
Correct. Correct. Shall I begin?
Please.
Thank you, ladies and gentlemen. Again, we believe we are in compliance with the two issues. On the noise complaint, there's been many, many complaints, and only one time that we were found to exceed the noise level. I think the sign and canopy is a typo. That's in the staff report, but I think that was something that they didn't delete when they wrote this report. The noise, exceeding the noise was a one-time thing. We do regular testing. We have an independent company that comes in unannounced and tests the music. We also have regulators on the musical instruments. And when the complaints do come, even though we're in compliance, we have been turning down the music. On the seating, the board has recognized an inequity of a situation. And here's the inequity. If you are a site plan case, which most of the Boston-Roslyn corridor is, then the board can give you however many seats you want. Unknown to us in a use permit situation, that's not the case. I'm going to hand out some material, and I'd like for you to go through it with me if you don't mind. The first document that you see in front of you is a policy statement that the board made. What happened is last time we were in front of the county board, we felt like we were somewhat ambushed by the violation notice because it was literally served on us during the board hearing. The staff started talking about this, and we didn't know what they were talking about. And then we learned that this violation notice had come about. Subsequent to that, the county board members thought about it, and they recognized that there was an inequity in the fact that you could have additional seating in a site plan, but you cannot in a use permit. So the county board said, all right, staff, we got to fix this. And the next document is a memorandum which went to ZOCO, which I think 3 of you used to be on, talking about the forthcoming zoning amendment to allow additional seating via the use permit. And that was well received at ZOCO. And in fact, the members of that committee wished that they would go even further and be more liberal in what they're going to be allowing. One of the things that I had always understood, and you'll see an email from me to Adam Watson, and I copied Mr. McIsaac. I had always understood the county board had that authority already, and and you can see in my email where I'm citing sections of the zoning ordinance where I believe the county board had the authority to grant more seating. When we got to the hearing, though, I eventually did get the determination that no, the county board does not have that authority. Now, one of the things that I wanted to point out, there were 2 emails the county board got. One is from Brett Baxter, and I'm just going to quote. He says in his email, and this was to the county board, this is not to you all. He's saying the live performances at the Beer Garden are wonderful events that draw lots of members of the community of all ages to the Westover Shopping Center. It is a unique experience in that parents bring their kids at very tender years to have dinner and see live music. The popularity of the spot has really grown because it is a great all-ages venue for live music and socializing. The next email is from Suzanne Sundberg, and she kind of continues on that same theme. Residents of all ages, including young children, gather to listen to music, catch up with each other. The spirit of community is live and well at the Westover Beer Garden. And then the next document that I had was, and this was intended for the last meeting that you all didn't have, and it was the reasons why we were asking for the deferral. And in the other jurisdictions where I've practiced law, as long as there is something in the works that will solve the violation, and there's nothing impacting the health, safety, welfare of the community, most jurisdictions let that go as long as the activity to bring it into compliance is underway. And that's been my experience in other jurisdictions. The applicant had these seats for several years. They just, added them gradually to allow people to sit rather than stand. And then the last thing is we need to share with you all that it's been very financially difficult for the Hicks family. They had the Seacraft restaurant, which unfortunately went bankrupt. And that has impacted them tremendously. And if they had come into compliance, we wouldn't be here because there'd be no beer garden. They would have simply gone bankrupt. They just had to have this available. A couple statements of support that you all may or may not have gotten. I'm going to hand those out and let you all evaluate those. We also, since the Rucker Company was cited, we also added them to our appeal, and the staff report is indicating that that the zoning ordinance applies to property owners, and in support of that, they say it shall constitute a violation of this zoning for any person, firm, corporation, either owner, agent, or occupied, disobey, neglect, or refuse to comply with or resist the enforcement of the zoning ordinance. They have no control over this. This is their tenant, and there's nothing that the Rucker Company could have done to have complied. It's out of their hands. It's their tenants' activities. With that, I'll be quiet and sit down, and I'll hand out these additional statements of support.
Any questions from Mr. Lawson?
Yes.
Mr. Hall.
Mr. Lawson, are you saying there's no factual disagreement about whether or not amplified music was playing after the permitted hours on whatever this date was, April 25th? I'll wait till you can return to the microphone.
Okay.
Mr. Lawson, I'll wait till you return to the microphone.
Okay, could you give me that question one more time?
Yes. Do you concede that amplified music was played after the hours it was allowed to be played on April 25th?
We don't know. That was what I tried to get my hands on was a police report. And when I went to, because the zoning violation is citing a police action. So I went to the police department. I said, well, can I see it? And they said, you have to file a Freedom of Information request. So I filed that, and they say, oh, we can't give it to you because it's a criminal matter. So we never have talked to the officer. We don't know. And so we don't concede that at all. And I think that, in all, it's hearsay. The police officer's not here. The police officer's not testifying. And we don't believe that we were playing after hours. And Mr. Hicks is here, and Devin Hicks is in the back, and they can speak to that if you'd like for them to.
I'll mull that offer over.
Okay.
Thank you.
Madam Chair?
Ms. Alice.
So did the landlord take any action to bring the tenant into compliance?
No, they did not file an unlawful detainer or anything of that nature.
Okay.
Okay, thank you. We have 4 speakers. Thomas Jurgen.
Good evening. I live across from the beer garden across Washington Boulevard, and I've been very concerned about noise for a long time. And just so y'all know, it's very hard to get the noise stuff enforced because code enforcement doesn't work at the times the music's playing, and the police don't have decibel meters, and they tend not to want to get involved. So they just close it out and say nothing found, regardless of what was going on. So enforcement's very difficult. I can tell you the piped-in music is still a problem, and I'm going to play something for you if you'll indulge me in a minute. The seating's important because a lot of the noise, I think, comes from so many people being there, and also just precedent. You know, they don't follow a lot of the terms of the use permit and the zoning ordinance, and this is just one more, and I think it would be helpful for something to be enforced that's very easily verified. And I did swing by this morning, and there's 14 picnic tables still, could seat 6 each. That's 84, plus 4 round tables. So we're over 90 seats compared to 29 allowed. I mean, that's not a small thing. And I also don't think it's a foregone conclusion that the county board use permit would, you know, I'm sure they'll get more seating, and I don't object to more seating per se, but I don't think it's a foregone conclusion the use permit as it exists in 90 seats is going to be approved after public hearings and everything. Now, this was the closing game of the National League NLDS the other night, and this is about 12:45 a.m. Friday morning, and
Sure, let me ask you, is this music you're going to play that was played there?
this is the crowd noise and the TV.
No, it's not music?
It's not music.
Okay.
May I?
It's germane,
Or
Madam Chair.
no?
No, thank
Okay,
you.
well, it was quite
Madam Chair.
loud.
What's wrong?
What's at issue is, in part, the seating limitation. I think that the speaker is saying that one policy justification for the seating limitation is crowd noise.
Certainly. Thank you. Our next speaker is Kirit. Help me out. Thank you.
Good evening. Thank you very much. I live in Westover.
Could you state
I've
your
lived
name,
there.
please? Could you state your full name, please?
Sure. Kirit Mukherjee. I live on Kensington Street.
Thank you.
I've lived in Westover the entire length of this business. So I've lived there over 10 years. I've read all the documents. I think the purpose of my testimony is to give you something that's not in the documents. I believe that this business, which is family-owned, has grown into the basically the gathering spot of Westover and Terra Leeway and a lot of the neighborhoods in North Arlington. I believe that this business is interested in being a good neighbor, and I have spoken to county board members, and I think there are some discussions about revisiting the seat issue regarding 29 seats being an acceptable number for a business of this size. The final point I'd like to make to you is that for a business that has live music, there have been relatively, compared to some other businesses in Arlington, few incidents, other than those cited of the noise, but few serious criminal incidents regarding, a business that's open 7 days a week and that has a lot of patrons. So I think that overall the business is a good neighbor, and reading your possible recommendations, I would urge you to support the alternate resolution, which would be null and voiding the original zoning decision.
Thank you. Howard Bubo?
Thanks.
Mr. Bubo, you're handing out a document to us.
This
It's your remarks.
Good evening, Madam Chairman and members of the board. I am Howard Bubel, a property owner in Westover, specifically of two buildings directly across the street from the Westover Market. They're garden apartment buildings, and we have a total of 16 families in the two buildings. Essentially, the market, we're about 200 feet from the market, and the beer garden, music, and entertainment venue. I represent and speak for the 16 families and their guests. There's a lengthy history dating back to at least May 17th, 2011, which you are well aware of, concerning the establishment of outdoor live entertainment. I cannot speak for all property owners and neighbors occupying homes, single family and apartment units in the immediate area, but noise after 9 p.m. coming from the cafe, outdoor entertainment area, is one of the single biggest factors, and about half of my family residents hear it. Noise after 9 p.m. is unwelcomed, and can be quite disturbing when you are trying to fall asleep because you must get up at 3 a.m. in order to make it to your place of employment. Consequently, this noise, whether it comes from happy, excited, or inebriated patrons, or piped in or live music or other sources such as outdoor television, all contribute to the community problem. Music is still being heard and is based on the 14 currently installed garden tables with seating capacity going beyond 28 seats. At 4 per table, occupancy would be 56. 6 per table, it's 84.
Mr. Bubel, could you wrap it up, please?
I'm sorry.
You have 2 minutes. Your 2 minutes is up.
All right. Thank you, ma'am.
That's all right. We have one more speaker, Sue Walton.
Hi, my name is Sue Walton, and I'm here to speak in support of the Beer Garden's request for a stay in enforcement on the seating limit on the patio. I think you've heard of the support of the community for the Beer Garden. It's really a neighborhood place that's unique in Arlington. It was kind of organic in how it's developed, but at this point, a lot of families gather there. If their kids are old enough, they go to Toby's for ice cream. It's just a nice way for people to be able to get together that they can't do in many other places, business and many other businesses. I know that you've heard from other people, including the Neighborhood Civic Association, which I believe wrote today expressing support for the seating. It's a pretty integral place to the community. What I wanted, the community has come out strongly in support of the Beer Garden, and after the violation was issued, a lot of people testified to the county board, wrote to the county board, and that prompted the board to seek a review in the zoning ordinance. My understanding from talking to planning staff is that a change to the ordinance will be advertised at this coming meeting, and it's likely that the board will then hear changes to the ordinance at the November meeting, which would likely allow for the board to grant increased seating. Absolutely, that would be, their decision. But it's likely that a lot of this would be moot, and that there is an effort to come into compliance. So I guess I'd like to encourage you to also think of the community as a stakeholder in this. Typically, I feel like these are viewed as disputes between the business and, and the board, and the community does have a big stake in this. I don't think the larger community knows that this action is going on. I think they feel like things were taken care of by the board's action. Thank you for your consideration.
Thank you. That's the last speaker.
Madam Chair?
Ms. Malice.
I'd like to clarify a comment the last speaker made. the speaker referred to a stay in enforcement. I don't believe that that is what our role is here. Our role is not to determine whether there's a stay in enforcement or not, but it is to validate or overturn the decision that the zoning administrator made. So I just want to be clear that we have no role in staying enforcement. Just to kind of share where I'm coming from right now, I think there's no question that this establishment is popular, especially with its patrons, but it's not popular with everyone because, as you heard tonight and we've heard before, that there are people that do not appreciate some of the results of having this establishment in the neighborhood. But our role here is not to say, we don't preempt the board. The county board may make zoning changes. They take a lot of community input in that process. We are a quasi-judicial organization that is basically asked to make a very narrow ruling here, and that is when the county zoning administrator issued this action, did she make it in error? And that is what we have to determine tonight.
Thank you. Other comments?
I have a
Mr.
question. Yes, I'm still a little confused about whether or not we are being asked to uphold the zoning administrator's determination on May 5th that the applicant had used speakers after hours. Can I get a clarification from the county attorney's office or the zoning administrator as to whether or not that's a determination that we're being asked to make tonight?
That is what generated this, essentially. That's complaint-based.
But the complaint has multiple parts.
That's correct, and one of them was that there was a noise complaint on that day, and when the police department went out to investigate, they did issue a report that music was coming from the speakers at I think 11:29, which is after hours. So that's one portion of the notice of violation. The goal is compliance, and we have not had other complaints that we've had to go out and investigate about noise or music subsequent to that. So I can't speak to that. You've heard from your speakers tonight. What the appeal does is stays further enforcement until you all have had a chance to decide.
So in the ordinary course, if leaving aside the seating for a moment, if the police come after 9 o'clock, they observe, they don't have their decibel meters with them because they're not trained on decibel meters. Only code enforcement is trained on decibel meters. But they notice that it's after 9 o'clock and they hear music coming out of a loudspeaker, then they're witnesses. And then the next morning they call zoning enforcement in this case, zoning enforcement. And zoning says there's a zoning rule that says that you couldn't do this after 9 o'clock. And so based on the witness, which in this case is the police officer, we're going to issue the notice of violation. And then if the applicant says, we're taking out the speakers, we cut the wires, there are no more speakers, the zoning administrator might take no further action on that notice. But the question before us tonight is not what should the zoning administrator do after the notice. The question is, was that notice correct in the first place? Am I understanding the question correctly? Correct. Mr. Lawson, do you want to address that characterization of what we're deciding as to the noise?
The violation notice on its face says you are directed to correct these violations by the compliance deadline indicated, which was 10 days thereafter. And so the issue that you were just talking about was resolved within the time period. And we had a subsequent meeting with enforcement, zoning enforcement, and they acknowledged, is my recollection, they acknowledged that the issue was the seating and not the, not the time of the noise.
Okay, thank you, Mr. Lawson. I didn't hear in that a dispute about what happened on the 25th. I know that earlier you said that you don't concede the facts, but what you're appealing is that notice. And so we're not, as it seems to me, as the Board of Zoning Appeals, it's not ripe for us to determine what happened 10 days after that notice, because what I believe you're appealing is what happened in that notice itself. So then my question is to the county attorney. Mr. Lawson appears to be saying that there's insufficient evidence before this body to uphold the zoning administrator because the police are keeping secret their witnesses. They're not providing their witnesses or their statements or their paperwork for cross-examination.
I think you have a statement in the packet that's a summary report. It's not their specific police incident report, but it is a summary report that said they showed up on that date at 11:29, and there was music coming from the speakers.
So then I would ask the zoning administrator, is that all that you relied on, or did you rely on more evidence beyond what's in our packet?
We also received a copy of the original police report. So we received a copy of the original report and the summary.
And the original report, I'm sorry, is the original report part of the stuff that's not yet been given to the applicant under FOIA? Okay. All right. Thank you.
Madam Chair.
Mr. Smith.
But conditions 10, though, I think we can look at a picture, and we've had testimony from the neighbor across the street and I don't think the applicant denied that there are in excess of 29 seats outside. I didn't hear a factual denial of that. The assertion that there was amplified music outside the permitted times is one that requires some evidence, which we don't have. And
We have some evidence, we just don't have all the evidence.
Admissible evidence. That summary statement wouldn't be admissible. The police officer would have to testify. But we have some evidence of condition number 10 not being complied with, even as of, I think there was hearsay testimony that someone, I don't know if they were in the room or not, but a zoning inspector was there today. But certainly we've got a picture from 10, I presume, and a lot of courts are taking that photograph with that date as prima facie evidence of the date that it was taken, though it could be altered. But let's just say it was taken today. I didn't hear the applicant say, I heard him say, we want another 12 days or 14 days of permitted of use. I think he gets that anyway. Say we uphold the zoning administrator, he files an appeal tomorrow. The circuit court is not going to docket this for a while, and it's after November 1st. But that's the messier way, the costlier way to the applicant, but he accomplishes that nevertheless, I think. I think on number 2, there are 2 issues, whether they were in violation of the noise, condition 8, the use permit, or condition 10, and it's and/or. It's either one. Either one puts them in jeopardy. That's where I am, Madam Chair.
Madam Chair?
Thank you. Ms. Malice?
On the point of the police officer's statement, I mean, I'm not a lawyer, and I don't go to trial, and I don't think that that's where we're going. We're talking about a zoning matter, but I will say that when we go to a grand jury and a police officer comes to the grand jury and says this is what happened, we rely on the police officer's testimony at that point. I guess it's a question for the zoning administrator. Did you follow normal procedure in this matter in terms of getting a police report and reviewing it and providing summaries to us, and was this normal procedure for you?
It's normal procedure for us to share information. So we have a lot of agents at the county that do enforcement. And so it's not uncommon for example, a building inspector to see something out in the field and report it. And we get the report, and it also includes information that's pertinent to zoning. And we can use that documentation to issue a zoning violation. So in this case, it just happened to be the police department that responded, but that's, I don't want to say common, but it certainly is consistent with our procedure.
From your standpoint, it's an acceptable party to report, acceptable, credible party to accept the.
Yes.
For you to accept the observation.
So I'll just note that state law permits a Board of Zoning Appeals to subpoena witnesses and swear them in. And so I'm a little surprised that we're not, it seems like there would be more ammo that could be brought on the noise question. Mr. Lawson, do you want to bring a witness to refute the the factual? I'd be interested if you are prepared to present a witness that will refute the fact that there was music playing after 9 o'clock at night on the 25th.
No, when I discussed this with the police department, their response was that they don't know why zoning doesn't give us the actual report. So I don't know what's in it. I have this summary.
No,
I disagree with that, but we don't have the report. So
I appreciate that. What I'm asking is, would you be prepared right now to provide a witness who was present at the time to provide their version of events?
There on that date at that time. April 14 at 11:30. Come forward and speak in the mic. They record this.
So we'd need to have your name.
So my name is David Hicks, and I own Westover Market with my wife. And I'm there every night. There's live music played every night from the time it starts to the time it finishes. I was there. I'm fairly certain I was there on April 14th. The police sometimes come by with a complaint very, very infrequently. Normally it's in April when people who have moved into the neighborhood and don't know about our permit, which by the way goes until 10 o'clock on Fridays and 9 o'clock on Saturdays. They will stop by, they'll check the noise and the sound of the bands, and they will not note anything. I never, until this last on the 14th, I'd never heard any complaints that were validated or substantiated. So on the 14th, the police came by. I did not meet the police. I was elsewhere in the market, and I was told they had stopped by. And they said, "Well, did you show them our permit? Did they get?" I don't recall the time, but if you say it was 11:30, the bands, we have never allowed a band to play beyond the permit hours, and the hours are stop at 10:00 at 10 o'clock on a Friday and 9 on a Saturday. That's it. When they're done, they're done. And there are TVs outside. I won't say there was other noise and activity outside. There certainly is, but the bands, the live music are done at the hours, and that's one of the reasons I stay at the market. So I personally ensure that the live music ends.
It's not a live music.
At the time of our permits. Again, I'm there every night, every single night that there is music.
I think there's a slightly different allegation being made, that the allegation is that there was amplified sound in the outdoor cafe at 11:29 p.m.
There is a
On April 14th.
radio. There is not live music.
So there was a radio.
Here's what they're saying. They're saying police responded for loud music coming from Westover is found to have not been playing loud music. However, the music came from the speakers, and you all have quit that, is my understanding. But so you don't remember the facts regarding the speakers?
No, I assumed that they were talking about the live music.
But the allegation that we're being asked to uphold is whether or not there was amplified sound in the outdoor cafe at 11:29 p.m. on April 14th. So or did you just say that there may have been a radio playing at that time?
There may have been a radio, and there may have been TVs. There are TVs outside, yes.
Thank you.
There was not amplified live music, which I understood to be the complaint.
Thank you.
Thank you.
If I could just draw the BZA's attention to, it was condition 13 that really is what's kind of at issue here. That's the one that the agreement is amplified music won't be played beyond the hours. Okay. And we're not talking about noise level here. We're just talking about whether or not it was played. Okay.
Okay.
Madam Chair.
Mr. Smith.
The Assistant County Attorney just referred to condition 13 is, I'm looking at a letter dated May 5 to Mr. Rucker and the Westover Market, which is the amended corrective action for the violation notice. And that, so apparently the initial notice cited 13, is that what you're saying? Yes, it says 7, 8, and 13. Okay, gotcha. So in addition to that, this is supplementing, okay. But it doesn't require any decibel levels, it's any radio is amplified, and so it's coming through a speaker, that is a violation after those hours outside. The seating appears to be, even today, to exceed 29. And I think that's got enough evidence.
Madam Chair?
Mr. Owen.
I'm persuaded that the notice that the zoning administrator issued on May 5th was correctly issued. It's my understanding that that's what's before us tonight, was the notice on May 5th correctly issued, and I believe that it was.
Would you like to make a motion to that effect?
If I can find it. Madam Chair, I move that in case V, do you want me to read the whole resolution, or do you want me to? Can I refer to it?
Certainly can. It's your resolution.
I'll read the therefore section. So in case V-11289-17-APP-1, that the Board of Zoning Appeals adopt the resolution provided in the staff, page 8 of the staff report. That reads in part, now therefore be it resolved that the BZA hereby affirms and upholds the zoning administrator's determinations in the April 26, 2017 violation notice as amended by the amended corrective action letter dated May 5th, 2017, because the number of seats in the outdoor cafe and the use of amplified sound in the outdoor cafe were violations of the conditions of use permit U-3297-11-1 for live entertainment at 5863 Washington Boulevard.
Second.
It's been moved by Mr. Owen and seconded by Ms. Malice to uphold the ruling of the zoning administrator. All those in favor? Aye. Opposed? Thank you.
Thank you.
Thank you. Next case, please.
Case number V-11290-17-UP1. is a use permit request by Ryan Fubini, the owner, to permit a setback of 5.5 feet to the wall instead of 10 feet as required, with 5 feet to the eave instead of 6 feet as required from the right side property line, and to permit a setback of 5.5 feet to the front porch instead of 10 feet as required from the right side property line, and to permit a setback of 5.5 feet to the rear deck instead of 6 feet as required from the right side property line, and to permit an aggregate side yard of 13.6 feet instead of 18 feet as required for a new 2.5-story single-family dwelling with front porch and rear deck in the R6 zoning district on a premise known as 1936 North Edison. Staff recommends that the board adopt the attached proposed resolution granting the subject use permit with conditions.
Thank you. And you would be the aforementioned?
Yes, ma'am.
Yes, sir. And just to correct your slip, you have 5 minutes, not 20.
I'm sorry. I'm the agent. I'm the agent's authorized agent.
Yes.
Okay. All right. Just want to make sure.
But it's not an appeal.
Okay. Gotcha. Thank you.
Okay.
Okay.
Questions for staff before we go to the applicant?
I do have a question. On page 2, the last sentence of existing conditions, it says, though the lot is substandard, it was determined that it is buildable per section 16.11 of the zoning ordinance. Are you using the word determined in the legal sense that there was a determination, or that you reviewed it and it, in the colloquial sense of determined?
It looks like the previous sentence says there was a determination issued in December.
Okay.
I'm assuming that's what that request was for.
Okay. I appreciate that because it comes up again, and I'm trying to. When you use the word determined,
right?
Do you use it in its legal sense?
We should be.
Okay. In that case, it's pretty clear that it follows. But there's another one that I wasn't so sure of.
Got it.
Okay. Thank you. Applicant.
Thank you. Thank you for the board for the opportunity to present this request. I won't go too much in detail. I know it's extended. And
Say your name for the record, please.
Skylar Ahrens. I know you guys have all had this for a while and been able to review it, so I won't beat a dead horse here, but I do want to emphasize and piggyback off the determination that was provided. We do normally request a determination from zoning prior to the owner purchasing lots, trying to do their due diligence, make sure everything's in order, and so that we try to minimize inconveniences with the BZA. It was determined it was a substandard lot, but buildable. I think the average lot size in that neighborhood is anywhere from 40 to 50 feet. This one, just over 34 feet. The house, as is designed currently with the request we are requesting, is only 18 feet wide. That was sort of the minimum I could get to work without trying to impose on the opposite neighbor on the outside. When we did do this layout, we tried to take in consideration all the neighbors. I always tell the owner they need to reach out to the neighbors directly. I never like to go out there myself personally because I think it's something that neighbors should deal with one another. So in discussing, I know that he did obtain support from several neighbors. And when designing the layout, we tried to push the structure closer. If you see, we didn't center it. It was because we were trying to give some leeway to the opposite neighbor that has 8 feet, which would be by right if we had a 10-foot setback on the corresponding side. So trying to give him that by right feeling that we could have given him. The bigger intrusion is toward the inner neighbor, who happens to also be the same owner of the adjacent property. So putting more of the burden on that same owner, so he can deal with any type of negative outcome, trying to sell a house or anything. It's really on him because he owns it. So other than that, I don't really have much more to contribute, but I am open to any questions you may have.
Okay, thank you. Any questions? Okay. Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11290-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval. All those in favor?
Aye.
Aye. Thank you.
Thank you to the BZA.
Next case, please.
Next case is case V-11297-17-UP1, and it's a use permit request by Rebecca Valentine and David Swift, the owners, to permit a setback of 7.6 feet to the wall of the sunroom instead of 10 feet as required from the left side property line regarding a structural alteration in addition to an existing encroaching sunroom in the R6 zoning district on the premise known as 6054 21st Street North. Staff recommends that the board adopt the attached proposed resolution granting the subject use permit with conditions.
Questions for staff? Applicant?
Hi, David Swift. We're just looking to bring our sun porch into a full year use and take the roof from angled to flat with nothing else on top of it. That's just about it.
Questions for the applicant? Mr. Owen?
Madam Chair, I don't have a question, but I just wanted to thank the applicant for this drawing that you had,
Yes.
which I think really made your case really clearly. So that was very helpful, and just thought I would point that out.
I'm glad you enjoyed it.
Whoever made that spent half an hour well spent, I think.
My wife has worked very hard on this.
Okay.
Madam Chair?
Mr. Owen?
In case V-11297-17-UP1, I move that the board adopt the attached resolution granting the subject use permit with conditions.
I'll second that, Madam Chair, and I presume the applicant has seen this staff report.
Yeah.
Okay, so you know what the conditions are.
Yeah, I've got it all. Yeah, I've got it on my phone. I've read it all many times.
Moved by Mr. Owen and seconded by Mr. Smith for approval. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Next case is case V-11298-17-UP1. It's a use permit request by William Stoppel and Shannon Cummings, the owners, to permit a setback of 18.4 feet to the front porch instead of 21 feet as required from North Nicholas Street right-of-way, and a setback of 17.7 feet to the rear deck instead of 21 feet as required from the 14th Street right-of-way regarding a new front porch and rear deck addition in the R6 zoning district on premise known as 1401 North Nicholas Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request.
Questions for staff? Applicant, please. Or David Isaac?
I'm David Isaac. I'm the agent for the owner and the designer of the structure.
Thank you.
It's fairly simple, straightforward. It's a front porch in a very traditional Arlington design, reasonably modest, yet large enough they could put porch furniture or swing on it and enjoy an Arlington front porch and a view of their neighborhood. Other than that, as I say, it's in a traditional Arlington design. The rear or side deck, depending on how you see it, was built with a variance before. It needs some restructuring. And for some reason, it had this odd angle to it that just doesn't look right. And we just wanted to square it off to keep it. It just looked weird. Well, I don't know why it was done that way, but you know, when we reframe it, we want to square off the corner and keep the deck they had. They enjoy the outdoors, and it's a beautiful tree-lined neighborhood, and that's pretty much it.
Thank you. Questions for Mr. Isaac?
We have, you're the agent?
Yes, ma'am.
So the signatures of support were collected by
the homeowner, yes.
Okay, and their homeowner is here. I just noticed that the staff report we have shows 3 signatures of support, and there's just a couple of neighbors that aren't included, and we wondered what the person directly across the street from you and the person across both at front and to the side.
Yes, ma'am. Shannon Cummings, owner of 1401. Both those are rental agencies, and every time I went to both places to try and get the individuals who are renting those locations, I was never able to speak to them. So, and I'm not aware of who the owner is of those 2. It's the same owner for both those rentals.
Okay.
Madam Chair?
Mr. Owen.
I just want to point out that I'm noticing this meeting that we're getting these graphics that staff are putting up, which are extremely helpful.
Thank you so much. Yes.
So I just want to express my appreciation for these new graphics.
Other questions, comments for Mr. Isaac or anyone?
Madam Chair, I think that is common that we find applicants reaching out to the adjacent homeowner, and they're actually not the homeowner, they're a renter. The notices that are mailed to the owner of tax record. Often those folk are not concerned about these kinds of things and often don't reply. Sometimes a neighbor is in contact with the owner because they've lived there a long time and they've moved away and now they're renting, but often we're faced with a situation just like yours, and that you made the effort repeatedly is helpful.
I'll just point out that this is exactly the kind of situation that was the basis for moving the entire meeting to tonight, so that we would have no question in approving something like this, that all the I's were dotted and T's were crossed.
Yes.
And that the mailing actually had gone to those folk, because that was a problem the last time. Therefore, I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11298-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith and seconded by Mr. Owen. All those in favor?
Aye.
Thank you. Next case, please.
Next case is case number V-11299-17-UP1, a use permit request by Ann and Mike Steenhook, owners, to permit a building in excess of 2.5 stories within 25 feet of a street right-of-way, regarding a new third-story addition above existing second-story walls in the R10 zoning district, premise known as 7100 27th Road North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Okay, it is 27th North, right? Because the slide says south. I just double checking.
It is north.
The report says north. Okay, just so we have it right in the record. Thank you. Questions for staff? Applicant, please.
Good evening. My name is John Fritsch. I'm with JF Design Studio. I am the agent for the homeowners. Ann and Mike are here tonight as well. Basically, the request is to allow for the viewing of the addition that's above the existing house. Basically, the new square footage is going directly above the existing brick house. There's a new front porch and a new rear porch, but the issue for this application has to do with the addition vertically. And the fact that the left end of the house, if you're facing the front, is just over the 25-foot setback. That also comes into play because of the calculation of the basement as it relates to average grade around the house. So if you take those four corners, technically what everyone understood as a basement is actually a story. So in this case here, the addition of what we feel is a second story, and we're treating it as a second story, is actually viewed as a third story.
Okay. Questions? No speakers. Okay.
Madam Chair,
Mr. Smith?
this is one of those odd things that folk discover when they want to do a renovation, when they thought I only had a one-story house. Well, not really in a technical sense, in a hyper-technical legal sense. So therefore, I'd move that the Board of Zoning Appeals grant the use permit in V-11299-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Mr. Owen for approval. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11300-17-UP1 is a use permit request by Michael M. Eaton, the owner, to vertically extend a non-conforming side setback of 4.7 feet to enclose an existing screen porch above an existing garage instead of 8 feet as required, and to permit a front setback of 24.8 feet to enclose an existing unenclosed porch instead of the 25 feet required from the 18th Street North right-of-way, and to permit an aggregate side yard of 9.7 feet instead of the 18 feet as required regarding the enclosing of an existing screen porch over garage and enclosing of a open porch over garage and enclosing of existing open porch on a single-family dwelling in the R6 zoning district on the premise known as 6049 18th Street North. Staff recommends that the board adopt the attached proposed resolution granting the subject use permit with conditions.
Thank you. Questions for staff? Applicant?
Thank you, Madam Chairman. For the record, I am Barnes Lawson Jr. I'll be brief. This house was constructed in 1941, and at that time, the side yard could be as little as 3 feet. So this house complied with the zoning ordinance when it was built. And by the way, this is in my neighborhood, right up the street. There are a number of lots along 18th and 16th Street that are also substandard in width and have homes that don't comply with today's zoning ordinance. When you look at the map, it appears that an awful lot of these homes on the undersized, under-width lots do not comply with today's setbacks. Staff has listed the similar use permits variances that have been granted in the close vicinity of this home. I think that demonstrates pretty conclusively that this is consistent with development in the surrounding neighborhood. My clients have secured statements of support from the neighbors and a favorable staff. We respectfully request that you grant this, that we believe it is reasonable. Thank you.
Questions? Motions?
Madam Chair, I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit in V-11300-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval. All those in favor?
Aye.
Aye. Thank you. Next case.
In case number V-11301-17-VA-1 is a variance request by Arlington Road LLC, the owners, to permit a setback of 30.6 feet to the wall from the Arlington Road centerline instead of 40 feet as required, and a setback of 11.5 feet to the wall from the 22nd Street centerline instead of 40 feet as required, regarding the renovation and rear addition to a non-conforming structure in the C2 zoning district on the premise known as 2205 Arlington Road. Staff recommends that the board defer the subject variance request to the November 15, 2017 BZA hearing.
Motion?
Madam Chair,
Mr. Owen.
does staff have any more specific information about the state of discussions with the applicant? Because I noted that at our last version of tonight's hearing, the recommendation was to defer to next Wednesday, and now the recommendation is to defer to November. And so I'm just wondering, could this be one of those that we keep deferring month to month to month into next year, or does it look like it's really close, or what's the state of discussion?
The current state is that at the time of the last meeting, we were recommending deferral so that we could get an updated proposed plat showing some things that were absent from the plat when it was applied for. Subsequent to that meeting, or the abbreviated version of it, we have now received an updated version of that plat, but it was after we had to make the application for this meeting, so there is an update that will have to be made to the application based on that plat. So it was unable to really be heard in its true form tonight, so we're asking that it be deferred to November so that we can correctly advertise it.
So it sounds like it's close.
Yes.
Okay, great. Madam Chair,
Mr. Owen.
I move that the Board of Zoning Appeals defer this item to the November 15th, 2017 BZA hearing.
Second.
Moved by Mr. Owen, seconded by Ms. Malice for deferral to November. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11302-17-UP1 is a use permit request by Boris Hamerty and Susan Lee Camerty, the owners, to permit a left side setback of 4 feet to the new front porch, 2.83 feet to the porch eave from the adjacent property, the same as existing, rather than 8 feet to the porch, 5 feet to the porch eave as required, and to reduce the left side setback to 4.63 feet to the wall of the building, 3.63 feet to the eave, from 4.8 feet as existing instead of 8 feet to the wall, 5 feet to the eave as required, and to reduce the right side setback down to 6.95 feet from the feet to the building from 7.1 feet as existing rather than 10 feet as required, and to continue a 5.9 foot right side setback to the eave, the same as existing, rather than 6 feet as required, and to reduce the aggregate side yard down to 10.95 feet from 11.1 feet as existing instead of 18 feet as required, and to permit a front setback of 20 feet to the porch, increased from 19.5 feet as existing instead of 21 feet as required, with 18.5 feet to the porch eave instead of 19.5 feet as required, regarding the structural strengthening, expansion of the second floor, rebuilding of the front porch, addition of rigid insulation and recladding of an existing non-conforming single dwelling in the R6 zoning district on a premise known as 3704 17th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Questions of staff?
Madam Chair?
Mr. Owen.
It appears that the advertisement description for this application is different than what it was before we deferred to tonight. Is that right?
Changes were made just to clarify, make it a little bit easier for the board to understand the walls and eaves. It is a very long request and was getting a bit jumbled in the earlier version. The substance of the request has not changed.
Okay. Can you go back to the previous slide? So in this slide, there is a tree that takes up about half, 2/3 of that red square. And it's my impression that that tree is dead and gone now. Is that right?
We don't know the answer to that. I think the applicant may be able to speak to that better than we could at this time. I can tell you that at the time the pictures were taken, the tree was still there, and we have heard that the tree has been removed, but we do not know the current state of it.
Okay. Thank you.
Applicants?
My name is Chi Joyce. I'm the agent of the owner. I will let the owner talk about the tree later. I just wanted to describe what we're going to do about the property. Pretty much we're going to keep the existing. We're not seeking for expansion on the footprint. The only thing, it's going to be a little bit larger than before. We're going to add an insulation on the outside. This house is going to be a green home, and we're going to raise the roof, ceiling height, and underpinning to make the basement livable. The rest of pretty much we're going to keep it. The coverage is not going to be changed significantly.
Can you answer the question about the tree? Oh, you're going to ask them. Okay. I would just like to make a comment that I remember the application for the house next door that was in terrible disrepair and has turned out nicely. So I hope your project will be also.
Yes.
Would you care to come forward?
I'm Madam Chairwoman. I'm Boris Harmony. So when we purchased the property, I mean, we loved the property and all the trees, and we had an arborist come because we were simply concerned about the tree because it is bounded directly behind it by the house, and immediately a couple of feet in front, there's a sewer storm drain. And the arborist told us that it simply was dangerous, which was unfortunate. We were hoping to keep it. And then I called around and followed procedures I could find. Was it a historical tree? Was it this tree? So it was just for safety purposes. And then I was subsequently informed by the neighbor at the end that 2 other trees had come down and hit their house. So it was at the recommendation of the arborist, something we would not have preferred to do.
Okay, thank you. Comments, questions?
I guess am I seeing 3 letters of support in the packet, or am I missing some?
The report says 4.
Okay, I see 4. But I'm trying to figure out which one is your neighbor? I guess this is a question of the applicant. The person with the concern about the tree, what was their address?
Oh, she's she's right at the end, and I'd spoken to her at the end of the.
Is she next door to you?
Yes, but she's the one whose apparently the 2 trees had fallen on, and I spoke to her afterwards.
Okay, so if you face your house, she's on your left?
She's on the right. She's at the end of the road.
There's 06. Now, you have a neighbor on the other side.
Yes.
3700. Do we have a letter from them?
Yes, we have a letter from all the surrounding neighbors.
I see 1706, 1707, 5620, and then the one that you said 37. So I just happen not to be seeing anything from 3700 and 1702, which would be the people across the street from you.
So there was the original submission, then after discussing with the staffer, because there was a mistake on the website with the link, and then I had subsequently spoke to everybody else surrounding and got theirs and forwarded to the staffer. So
do you see the graphic up here?
Yes, ma'am. So
the graphic shows neighbors that we've heard from in your packet.
Directly across from us,
yes.
You have a letter was sent to the staffer subsequent to the package, and the neighbor to the right also have a letter from them.
302. Let's see here.
I'm sorry, we have a lot of papers in front of us, so give us a chance to.
I think that's the reason for the confusion.
I don't see it. We don't have that. We don't happen to have that letter, those 2 letters, in front of us.
Can you tell us the names of the neighbors who live next door in 3700?
I forgot her name.
Yeah, hi, Madam Chairwoman. I'm Susan Lee Carmody. I'm also an officer of the court in the state of New York. It's Melissa and Jeff Bishop at 3700, which is the lot paralleling our lot. They actually have introduced us to the general contractor who fixed up their property. It was in very similar conditions, and we have been communicating very in detailed manners and had several meetings with that contractor. So they are very aware of our plans. The person across the street, I have his last name. His name is Mike. He's in mortgage financing, and he also is well aware of our plans. I can't tell you that I personally saw a letter, but I've personally met and spoke with him several times.
And what about, no, that's fine. So I'm sorry, Mr. Harmony, is that right? So are you saying that you believe that additional letters from 3700 and 1702 were submitted, but that they're just not in our packet? Or do you think that they might? I'm just confused about what your view is about what the feedback you've gotten from them.
I went and showed them the full architectural drawings. I got them to sign the letter, and then I emailed them to the staffer that I was in contact with about the problem on the link on the website was not functional.
Okay, so you're saying that you did get a signature of approval from 3700?
Absolutely.
And you did get a signature of approval from 1702?
Absolutely.
Thank you.
Other questions? Comments? Issues?
Madam Chair?
Mr. Owen?
The zoning ordinance, at least, I can't remember whether it's in the state law as well. Maybe it's just the zoning ordinance. Specifically requires us to consider the impact on significant trees in granting a use permit. And the tree that was in front of this house was significant, massive tree. And among the comments that did make it into our packet, one of the neighbors, maybe two of the neighbors specifically said, hope we can keep the tree. The applicant, it's clear that the applicant told the neighbors that they would hire an arborist, and they did hire an arborist. So I guess I'm not feeling like the applicant's course of action here is totally unreasonable, but I'm a little bit concerned about what we're supposed to do as a board in these kinds of circumstances. And I wish that there was a little more guidance from staff about the fate of this tree and what it means that this tree is already gone. So I just feel a little bit lost about how to react to that.
Madam Chair?
Ms. Malice?
Mr. Owen, if there had been a report from the arborist, would that have dealt with your unease?
Yeah, I think so.
Yeah, I think that's what's sort of missing here. Does such a letter exist?
We do not have anything from the arborist at this time. I would like to say, however, for the record, that I do have an email from the applicant that has 7 letters of support that came in after the original packet was made that did not make this packet. For that, I apologize, but it is on the record now.
Great, thank you.
Can you come up and answer the question that was asked about the arborist?
You can certainly get the arborist to write a letter for a report of the tree and do analysis, submit it to the county.
Okay. I think that, personally, I'm all for saving trees, but I think that the safety of the neighborhood and the house is also germane, and it could very well have been that the tree was gone before the application. It was just, in which case it would have been moot. So I'm not persuaded that that's a problem.
A neighbor thought that the tree was still here when they were commenting. That's why they're raising it.
Well, that neighbor's house may not be in jeopardy either.
Another point that I wanted to make is that we could do the site coverage analysis. We understand the county requirement for the tree coverage for each property, and we will see if we are lack of the coverage of the trees, we could replant a tree to meet the requirement. If it's not, it's undercovered.
Madam Chair?
Mr. Smith?
I imagine there was a bill, there was some payment for this arborist, I imagine, who took down the tree. I imagine they wrote something about the condition of the tree on that piece of paper, on that bill, that taking down a roots compromised tree or partially dead or whatever, however they would describe it. I'm sure they made some description. Right. That would satisfy me. It wouldn't have to be a full-blown arborist report that you're asking, because they may not have done that. They may have just looked at it and said, oh yeah, it's got to come down, and described how that was, and then issued a bill after doing the work. So
we can certainly submit that.
That would satisfy my concern with respect to whether the tree was, whether it had to come down. But I could see from that earlier photograph with the house, the foundation of the house right there, and then the storm drain in front of it, that those are going to be conditions that are going to compromise a root system anyway. And with heavy rains, the age of the tree, top heavy, history of trees of similar size, of the same soil, the same neighborhood, toppling, it's all consistent with take it down before it comes down on its own accord.
Any other comments?
Madam Chair, just does staff know what the tree canopy coverage requirement would be for a single-family home like this?
I don't know that there is a requirement for single-family residential.
I know that when houses have been built in our neighborhood, there's been a requirement that a certain amount of trees are planted for new construction. I don't know if it applied to...
For projects that exceed 2,500 square feet of land disturbance, there's a plan that must be submitted, and there you have to comply with Chesapeake Bay ordinance and other ordinances that we can't speak to. So it's possible as a requirement for some other
Got it.
county requirement that happened. But I don't know that there's an absolute percentage, for example, for all single-family residential.
Maybe on new construction.
And another, for me, a question is whether or not the tree's fate is tied with the construction. If the tree is dangerous or dead, no matter whether the construction happens or not, that's relevant. If the tree was cut down the day before the application was filed when it didn't have to be so that they could get rid of an issue, to me that's relevant because then that's connected to the construction. I'm just stating general principles here. So I guess maybe this is sort of a lesson learned that when there's a tree like this at issue, it'd be helpful if word got out that it's helpful to have a writing from an arborist in this kind of situation, and that might save us time at future meetings.
Other comments?
Madam Chair, since
Ms. Mel.
we can't determine all these facts here, I'm prepared to make a motion supporting this application.
Please.
I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V11302-17-UP-1, subject to the conditions listed in the proposed resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Smith for approval. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Next case is V-11303-17-UP1. It's a use permit request by Timothy F.U., the owner, to permit a setback of 18.2 feet to the new wraparound porch from the 5th Street North right-of-way, reduced from 19.5 feet as existing instead of 21 feet as required, with 17.2 feet to the eave rather than 19.5 feet as required, and to permit a front setback of 17.9 feet to the front porch from the North Irving Street right-of-way, increased from 15.9 feet as existing instead of 21 feet as required, with 16.9 feet to the eave instead of 19.5 feet as required, regarding the addition of a wraparound front porch to the front and sides of a single-family dwelling in the R6 zoning district on a premise known as 3201 North 5th Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Questions for the staff? Repeat appearance by Mr. Schuyler.
Yes, ma'am. Skylar Aarons again.
5 minutes.
Yep, thank you. Again, thank you to the board for the opportunity to present this case. Again, I realize you've had these in your possession for over a month now, and you've gone over it again. Just reiterating, the permits have already been approved, and construction is commenced for the second-story addition. So the picture you're seeing isn't technically kind of the existing structure, if you will. We already obtained permits to increase the structure and height. And then so this is kind of the second portion that we wanted to do after we received approval. As you can see, it greatly is more attractive as I presented it than where it currently stands, or even without it under the first version of the currently approved building permits. So with that, I do believe we do have quite a bit of support from neighbors, and I leave any of my remaining time to you all for any questions you may have.
Questions?
Madam Chair?
Mr. Hall?
Did we get additional support from neighbors since the last version of this meeting?
I don't believe.
It says we have one signed by 4.
Another one of these nifty graphics. This is great. So much easier. Okay, so it looks like 419 Irving, 3209 Fifth, 505 Ivy, 415 Irving that we appear not to have heard from. Can you tell us about the outreach to those neighbors?
Again, I would reiterate, I usually do not reach out to the neighbors. I leave that to the homeowners. If the homeowner is here, I could ask him to step forward and address.
That'd be super.
It might be just a matter of not being able to get a hold, but I could definitely have him come forward.
Okay.
Yeah, that summarizes it pretty accurately. We've just tried outreach and haven't been able to get a response.
How did you try to reach them?
So we actually currently don't live in the property, so whenever we try to catch people when they're like either walking their dogs, which happens pretty frequently in the neighborhood, or we go and knock. I went around and knocked on everybody's front door, but if they don't answer their front door, I can't get signatures. So
Do you know the names of the people who live in those houses?
I don't.
Thank you.
I would follow up and reiterate that obviously all the neighbors are informed through certified notice and obviously advertisements to the neighborhood. As far as I know, no one's objected, as far as I know.
Again, thank goodness we deferred the hearing.
Yes.
Otherwise, that wouldn't have been true.
Okay, thank you. I have one speaker, Joan Arsenault.
Good evening. My name is Joan Arsenault. I live at 509 North Ivy, which is about 1 foot away from our property lines touching. And I am strongly in favor of this porch. We live in an old neighborhood. Ashton Heights has been around since the early 20s or maybe even before. We have small lots. We have small houses. People sit in the porches because we have big porches. We get to sit in the porches and talk to the neighbors when they walk by. The one that's a new house, a bungalow, 25 foot back from the street. They have a porch that's about this wide. You can't sit in it, and it's isolating. So these whole new ideas about these big setbacks, it's not neighborhoodly. It's not neighborly. You lose them, and we have them. We all have, almost all of us have big porches. And to deny those people a porch is to deny them from our neighborhood. And that's why I'm pushing for the big.
May I ask? I'm sorry, Madam Chair. May I ask a question?
Mr. Hahn.
May I ask how you found out about tonight's hearing?
Got a letter. I saw it on the trees, the yellow letter for September, and then I got a letter in the mail.
And then you said, this is something I got to support.
Yes.
All right.
I'm strongly supporting. I mean, it's not just a... And by the way, they didn't say, the house next to them that's in purple, I'm not sure what the number is on Irving. I've talked to them recently, and they are also in favor of it. I don't know if that was one of the ones you said a letter in or not.
Which one?
The one on Irving next to them, it's in purple on the map.
Yeah, that's...
We got a letter from them. It's the ones without the purple.
In favor. I was talking with them recently.
Do you know about the neighbors, anything about the neighbors across the street?
505 is basically they've been living in Chicago for work.
Uh-huh.
So they're not here, so they probably got it, and they're not here. And the one at that corner, that's another
3209.
3209. She's a lawyer and works ridiculous hours. I don't know if she cares what we do. But she's on an even smaller lot. Well, actually, our 4 lots are all the same size, but hers feels smaller because it's the corner lot and she lost it. The thing. She does not have a front porch, but she has a side porch. But because it's the corner lot, it's close to the street also.
Thank you.
And one more, sorry. The little. On the other side of Fifth Street, that little house next to the purple one, I'm looking down, like
501.
20, I can't read, I'm sorry, my eyes are 3209. That one's also, I know those people, I haven't talked to them recently, so I don't really know how they feel, but they don't have a porch, so maybe they don't feel as involved in it as I do.
Okay.
Thank you for letting us know that our outreach actually works, and thank you for coming. Any other questions or comments?
I am disturbed that we don't have more neighborhood input here. I don't know what to do about it because, you know, the application isn't disturbing, but, you know, we just don't have a good sense of, you know, kind of where people stand. I don't know how to proceed. I'm thinking about it, but it's just, and I don't know if this is a question to staff. You collect this information, and this is an application that's preceded you, but if I was staff, I would be warning the applicant that there's some jeopardy here, that since they don't have input from a sizable number of neighbors here.
We've talked on numerous occasions before about restructuring the application to make even clearer that that we expect this. I mean, in other jurisdictions in Virginia, the responsibility for notice, the legal and financial responsibility for making the notices falls on the applicant. And as a courtesy, Arlington County has decided to take up that cost of sending letters. But state law is sort of constructed with the premise with regard to variances and use permits and actions by the BZA that there's a premise sort of embedded in the state law that gives us our power to act that presumes that there's knowledge and conversations and input going on with the neighbors. And so sitting back and relying on the letters that we send, and that's a stopgap. That's not the main deal. The main deal is that we expect either that the neighbors will have weighed in writing, or that we have an excellent rationale for why they didn't. I knocked on their door 5 times. I sent them a letter. I left a note, you know, that kind of thing. And so this is far less results and apparent effort than we're used to seeing for applications like this.
I would note I do several use permits throughout Northern Virginia and many jurisdictions, mostly actually in Fairfax County. So I'm aware, yes, we do actually send out the notices ourselves. It's about $80 for 11 adjacent neighbors that have to go around. But also in the other jurisdictions, there is no requirement to reach out to the neighbors.
Well, that's the requirement. The requirement is to send those letters.
But the letter of support that you guys generally request at BZA hearings is not required in other jurisdictions.
We don't require letters. We encourage letters, but what we expect is to hear about what the extent of neighborhood engagement is. And there are plenty of other jurisdictions in Virginia that have similar expectations of applicants. And in lieu of, in our case, in lieu of actually the legal notification. But anyway, the point is, we're not treating you differently than everybody else. We're responding to a different presentation than we're used to getting.
Okay.
Other comments? Motion?
Madam Chair.
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit V-11303-17-UP1, subject to the conditions that are listed in the staff report.
I'll second. Moved by Mr. Smith, seconded by Ms. Freshman for approval. All those in favor?
Aye.
Aye.
Thank you to the board and staff again.
Thank you. Next case, please.
Case number V-11304-17-UP1 is a use permit request by Brett Bontrager, the owner to permit a front setback of 24 feet to the front wall rather than 25 feet as required, and to permit a structure of more than 2.5 stories within 25 feet of the street right-of-way, and a front setback of 19.8 feet to the porch with 18.8 feet to the porch eaves rather than 21 feet to the porch and 19.5 feet to the porch eaves as required, and to permit a left side setback of 5.9 feet to the building with 5 feet to the eaves instead of 10 feet to the building and 6 feet to the eaves as required, and to permit a left side setback of 5.9 feet to the porch with 5 feet to the porch eaves instead of 10 feet to the porch and 6 feet to the porch eaves as required, and to permit an aggregate side yard of 13.6 feet instead of 18 feet as required regarding a new porch and second-story addition to an existing single-family dwelling in the R6 zoning district on the premise known as 1500 North Potomac. Staff recommends that the board attach the proposed resolution denying the subject use permit request for a front setback of 24 feet to the front wall rather than 25 feet as required, and denying a structure of more than 2.5 stories within 25 feet of the street right-of-way, and approving the front setback of 19.8 feet to the porch with 18.8 feet to the porch eaves rather than 21 feet to the porch, 19.5 feet to the porch eaves as required, and approving a left side setback of 5.9 feet to the building, 5 feet to the eave instead of 10 feet to the building, and 6 feet to the eave as required, and approving a left side setback of 5.9 feet to the porch, 5 feet to the porch eave instead of 10 feet to the porch, and 6 feet to the porch eave as required, and approving an aggregate side yard of 13.6 feet instead of 18 feet as required. An alternative resolution has been provided should the BZA wish to approve the use permit as advertised. I would also like to note that there is supplemental material for this case. There's an additional 3 signatures that were actually a part of the last application package.
Thank you. Questions for staff?
Madam Chair.
Mr. Owen.
The staff recommendation appears to have changed since the deferral from the last meeting. Can you talk about the change and why there was a change?
Subsequent to the last meeting, I met with the applicant, and he discussed that we may not be casting a wide enough net to look at the surrounding area for comparable structures. So I did additional research, found examples for setbacks similar to what he was looking for. In all of the research I did, I was still unable to find an example for the portion that we are denying, which is the 2.5 story or a portion of the house more than 2.5 stories within 25 feet of the right-of-way. So we came up with a split determination as opposed to the all-out denial that we recommended last time.
Thank you.
Applicant.
Hi, good evening. I'm Brett Borntrager. I'm the owner of the house. And I want to thank Stephen. As he mentioned, I went and I met with him after the last meeting, and we discussed a lot of things, and I had some examples that I showed him. One of the main things was the street that my house lives on. There's only about 10 houses on it, and so it's kind of a triangle with 2 other small streets. They're all considered, I think, part of the neighborhood, and so that's why the change was made, because there's a lot of other houses on that triangle of streets that have been renovated. But if you just look at my street, a lot of it is the original look of the original house. I understand the recommendation is to deny part of my application for a use permit, but I humbly ask you to reconsider because of the restrictions of my lot and other factors. I'm not looking to flip, but this will be my family's forever house. I have owned the house since 2003 when I bought the house from the original owner. I currently have a wife and 2 kids and expect a new baby in the spring, so we really need the additional space. The 2 closest neighbors next to me and the neighbor directly across the street have submitted signatures in support. When Route 66 was built in the 1970s, it cut 2,000 square feet off of my property, making it an odd shape and making it unable to have a larger rear addition. My lot is only 50 feet wide, making it difficult to add living space on the side like the neighbor directly across the street did. I feel the renovation would fit into the neighborhood. We are asking to build on top of an existing screen porch, but not expand it any larger. The screen porch foundation is integrated into the main foundation block walls of the house and is very sturdy. So the previous addition of the screen porch was very significant. It wasn't just flimsy. I have a 1970s map of the Route 66 plan that shows my house, and you could see the screen porch already existed on the side. The part of my application that was denied was the upper part that extends 1 foot into the front setback. If you look at the diagram, it is only this piece right here, because it's kind of like has a kind of a trim detail that juts out 1 foot. So it's just this piece right there. Some of my neighbors, I was able to get some insight on the whole BZA process. My neighbor actually had the same exact house that I did. All the houses on the several streets were originally exactly the same. And I brought his BZA diagram for his house, and I have it here if you'd like to view it. But the shaded areas are the part that he gained approval. This house is at 6261 18th Street North. So he gained approval in the for an upper front addition that went into the front setback. So I just want to point that out, and I'd be glad to distribute this if you would like to see it.
Yes, please.
Okay.
Give it to the staff.
The one difference concerning the 2.5 stories is that their basement had, it was more covered, so it was not considered 2.5 stories, where my basement, the back of my yard slopes, and so more of my basement is technically above ground. So that's where the 2.5 stories come into play. I don't have any neighbors to the left or to the back of me because of Route 66. But I have gotten approval of, you can see the ones shaded right around me. I also have, you mentioned an arborist. I believe I have the correct arborist plan. If you would like to see it, I'm not cutting down any trees. So if you would like to see that, I could show that to you. Okay. I also have an email of support from my next door neighbor. I believe, is that in the packet, Stephen? I had given it to you last meeting, so I'd be glad to distribute that if you want to see the email of support for my next door neighbors. I'm not sure.
I think we've got it.
Those are just signatures, but I don't know.
Okay.
If you'd like to see it, though, I have my next door neighbor's support. Please consider these details. Okay, I'm done. Thanks.
Thank you. Any questions for the applicant?
I have a question.
Yes.
Who owns the property to the left of you? Not the single family home, but
Yeah, if you're looking at my house to the left, it's county property.
County.
All of that, yep.
Okay.
Because of Route 66, yes.
Retaining wall.
It's a retaining wall.
sound wall.
Yes, it's a wall.
So sometimes, thank you.
Sure.
Sometimes when we have this kind of situation, we wonder who speaks for the county. Does the real estate office weigh in on these sorts of things?
Not typically.
Do they get the written notice?
We send it or give it to whomever we follow the same process. So we click on all of the parcels that are adjacent.
Is that a clickable parcel?
Yes.
Looks like it.
That
It
little
has a
triangle there?
boundary. It's an odd shape, but it looks like it has a.
So probably there's some bureaucrat in the county that got a letter from you that said, how do you feel about this renovation? Okay.
Well, Madam Chair, but it doesn't have an address, though, that land.
I don't know.
So they wouldn't have gotten mail.
Well,
Just because it doesn't have an address doesn't mean we don't have a taxpayer of record.
Well, okay.
the owner has an address of 2100 Clarendon Boulevard.
But let's see, you have a tax map in here. How would it be designated?
By whatever the legal description, the RPC and the, yeah.
RFID, yeah, RPC, that's what they're called, right? Yeah, I'm sorry. You were ahead of me.
Okay, moving on.
So what are your, Madam Chair?
Yes?
The applicant, what are your objections to staff's recommendation?
I just would like to consider that it's kind of a technicality with the 2.5 stories. Because of my basement, it's an unfinished basement, and it's the whole front of it is underground. But I will adhere to whatever you decide.
Madam Chair.
Mr. Owen.
I guess I'm wondering for staff, I was just reviewing the ordinance requirements that are in the staff report and trying to match it up to the recommendation. There's two, and thank you, by the way, for underlining the denying and approving words, which again makes this conversation easier and faster. But there's denying is underlined twice, as if there's two different requirements that you're denying, that you're suggesting that we deny. One is to not have 25 feet setback, and then there's a separate denial being recommended for having a structure more than 2.5 stories within 25 feet of the right-of-way.
It's really
The
one.
2.5 stories, 25 feet is connected. If it was, that's why they asked for it.
I don't understand why there's two different things to deny. They seem like the same thing, or that one would be subsumed in the other.
It's two separate portions of the ordinance. The 25-foot and the 2.5 stories are both, in this case, in conflict with the proposal.
Oh, I see.
Yeah, even if the proposal was 2 stories, it would still be too close.
Yeah.
Right.
Got it. So it says nothing should be within 25 feet, and we really, really mean it when we say
Yes.
nothing within, it's 2.5 stories.
Yes.
Got it. Okay.
Madam Chair,
Mr.
except this is
Smith.
like that case earlier where you have the legal fiction that it's a 2-story, that the basement is the first floor, when really it's the basement. But you're on a slope, and so the back makes it appear as if it's the first floor. And that's why he's objecting to that kind of characterization. It just seems to put form before function.
It's
As so often the zoning ordinance does. Well, the function is that that's a basement. The form is that, we'll call it a first floor, at least part of it. So I object to it. I don't find a problem with the application. And my view would be I'm sure there's an alternate resolution showing approval of what was requested. That's what I would move for at the appropriate time, Madam Chair.
Like right now.
Go for it, Mayor.
Madam Chair, I move that the Board of Zoning Appeals adopt the alternative resolution granting the use permit as requested in V-11304-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Mr. Owen for approval of the alternative resolution as advertised. All those in favor?
Aye.
Aye.
Thank you very much.
You're welcome. Next case, please.
Case number V-11305-17-UP1 is a use permit request by Stephen Chan, the owner, to permit a front setback of 19 feet to the building, 18 feet to the eaves, instead of 25 feet to the building and 21 feet to the eaves, as required from a public easement adjacent to the 23rd Street North right-of-way, regarding a 2.5-story front addition, including an open porch on a single-family dwelling in the R6 zoning district on the premise known as 5512 23rd Street North. Staff recommends that the board adopt the attached resolution granting the use permit with conditions.
Thank you. Questions for the staff?
Madam Chair.
Mr. Owen.
The map included in our packet does not have lot lines shown, as is usually. There we go. So the green lines didn't appear in our packet like they usually do, and so that made it a little harder to see what was going on. Thank you.
Other questions? Applicants?
Good evening. Thank you for the opportunity. My name is Steve Chan, the owner. Obviously, we've read the report and agree with the staff's recommendation. Wanted to point out that it is the request that we're asking for is relatively modest, and in fact wouldn't be needed if there wasn't that 10-foot public street easement. And we do believe that the structure that we're are suggesting does match well with the development in the community. Be happy to answer any questions.
Questions for the applicant? Hearing none, thank you.
Thank you very much.
Madam Chair,
Mr. Smith.
I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11305-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Madam Chair,
Mr. Owen.
I'm going to oppose this motion. I think that staff has only two instances that it's citing as precedent for this encroachment. One of them is the corner lot, and corner lots are sometimes special. And the other one, to my considerable surprise, is an apparently illegal house on the same street, if I'm remembering correctly. Where they, despite encroaching into the required 25-foot setback, there is no record of relief granted by the Board of Zoning Appeals. This appears to have been an oversight during review, with the setback measured from the publicly dedicated right-of-way instead of the public street easement. So someone made an error, and that's being cited as a precedent for the BZA to approve more of the same. So that's concerning to me. I do not see as many neighbors for such a precedent-setting encroachment. I don't see as many neighbors on the street signing up for approval as I would like. And then also, can you flip back to the aerial photo? You see that, you can see in this photo that this side of the street has at least one monster home on it now. And that's mitigated by the fact that there's this extra setback because of the utility easement.
Or sidewalk easement.
Yeah, but there's more easement than is, would ordinarily be given by the curb.
Street purposes, but.
But in any event, I just feel like, there's sort of a trade-off between one of the purposes of the setbacks and the lot coverage ordinances that we're asked to consider is to address the conversion of neighborhoods into sort of monster home type neighborhoods. And so that seems to be what's happening here. I see that we don't have any articulated neighbor objection. Once again, we deferred this meeting, so we know the letters did go out. But I just feel like this, in my opinion, this does not promote compatibility development with the surrounding neighborhood because the overall footprint size and placement are not similar to the structures or properties surrounding the subject property. And it would, and so I don't feel it meets the criterion. But I recognize that there's probably plenty of votes on the other side.
Thank you.
Madam Chairwoman?
Yes.
May I address that last concern?
It has. Oh, yes. Okay. That's all right. Been moved and seconded. All those in favor? Aye. Opposed?
No.
It's approved. 33-1. We'll have a 5-minute break, please.
Thank you.
I hate that the last one.
season, right?
He didn't hide it. He didn't make up anything.
Right.
Ms. Barnes didn't hide anything. He didn't make up anything. That's the actual reason why.
I wrote them down.
2 weeks more business.
That's interesting.
Okay, we're ready to go. Next case, please.
Case number V-11306-17-UP-1 is a use permit request by Elizabeth Dulabon, owner, to extend an existing non-conforming front setback of 12.8 feet from the 6th Street North right-of-way to a new rear addition, 11.8 feet to the eave rather than 25 feet to the addition and 21 feet to the eave as required, and to extend an existing non-conforming 4.8-foot side setback from the adjacent property line to the walls of the front addition, 3.8 feet to the eaves instead of 8 feet to the front addition and 5 feet to the eaves as required, and to extend an existing non-conforming 4.8-foot side setback from the adjacent property line to the walls of a rear addition, 3.8 feet to the eaves instead of 8 feet to the rear addition, 5 feet to the eaves as required, and to reduce the aggregate side yard to 17.6 feet from 18 feet as required, regarding a proposed 2-story rear addition and 1.5-story front addition on a single-family dwelling in the R6 zoning district on a premise known as 600 North Jackson Street. Staff recommends that the board adopt the attached resolution granting the use permit request with conditions.
Thank you. Questions for staff? Applicants?
I'm John Hensley, architect and agent for the applicant. I'm here to answer any questions you may have. I also know that one of the neighbors is here to speak in support.
Thank you. Questions for the applicant's representative? Okay. Scott Cater.
Good evening. My name is Scott Keeter. I live at 601 North Kenmore Street, which abuts the property of the applicant at the corner of 6th and Kenmore. My wife and I strongly support their application. We've examined their building plans. We don't think it will have any adverse impact on our property. And in fact, I think it will contribute to the attractiveness of the neighborhood. Thank you.
Thank you. Mr. Owen.
I'm wondering if the applicant can speak to the outreach to 524 North Jackson Street, across the street. So on this map, there's purple for the ones where we've heard from the neighbors. And then at the corner of 6th and Jackson, same intersection as the application.
Yes.
524 North Jackson Street. It appears we didn't hear back from the neighbors.
That applicant has been a neighbor of theirs for many, many years, but she has recently moved to a senior living facility and isn't
harder to track down then. Yep, makes sense. Thank you.
Any other questions? And
my understanding is that the the property just to the north of the applicant, what is that, 604? That is the house is being demolished, right?
It has been demolished.
Demolished,
Yeah,
so it's under new
demolished,
construction.
BCN demolished it last week.
And has there been any contact with the owner of that parcel?
There was a conversation between the prospective owner and my clients. Yes, it was a positive conversation, but
okay. Thank you.
Any other questions, comments?
Madam Chair.
Mr. Smith.
In the case of V-11306-17-UP1, I move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit with the conditions listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11307-17-UP1 is a use permit request by Jeff and Larissa Powell, the owners, to permit a setback of 19 feet from the 11th Street right-of-way to the front porch with 18 feet to the eaves instead of 21 feet to the front porch and 19.5 feet to the eaves as required, and to permit a setback of 7 feet from the left property line to the wall of a two-story addition instead of 8 feet as required, and to permit a setback of 9 feet to the side porch from the right property line instead of 10 feet as required, and to reduce the aggregate side yard to 16 feet from 18 feet as required, regarding the addition of a one-story front and right side porches and two-story addition to a single-family dwelling in the R6 zoning district on a premise known as 5755 11th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I'd like to note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you. Questions for staff?
The supplemental material is an October 16th letter from a opposing neighbor, right?
Yes. Maria Ahern. Applicant?
Hi, I'm Larissa Powell. I'm here with my husband, Jeff Powell. Our house is a colonial built in 1940 in Westover. It has a small addition on the back that was put on by the original owner. When we moved into the house, we had one small child. We now have 3. So we are trying to expand the home to accommodate our family of 5. We love the neighborhood, and we'd like to have our kids grow up in this house. So we're really just doing it to try to make more room for us and the kids. We've notified our neighbors. On the left, we live next to Westover Baptist Church. So they actually sent an email of support after the last hearing. So they support it. The 2 properties across the street, that one on the corner there, she also signed our statement of support on the day of the last hearing when she sort of came in late and I told her not to worry about it, but then when we got the notice of the mix-up, then I went over there the day of the last hearing. So she signed it, so I think that's in the updated package. And then other neighbors in the area. We notified our neighbor to the right, that's a tenant property. For as long as we've lived there, it's been tenants. So we've only met her in person once or twice, but I had emailed with her. And so we received notice on Friday that she objected to the side entrance. We had been more focused about the office, obviously, because that's the 2-story addition. So on her side of the property, there's going to be a mudroom entrance, and the goal there is my 3 children walk in the door and dump their stuff all over the living room. So we're trying to create a mudroom, keep our life organized. So that is what's coming out 1 foot closer to her property line. Everything else on that side is sort of set back behind the original house.
Questions for the applicant?
So you only learned in the last couple of days about the objections from your neighbor to the right?
Right. So I had reached out to her around Labor Day, and she was traveling, and we exchanged some emails. And then I initially was, because we were focused on the other side, I didn't realize that because the mudroom entrance is coming out as far as an existing basement areaway. And so I'd explained that to her and hadn't realized that it was going into a setback. And then before the last hearing, when I saw the staff's report, I sort of had a moment where I thought, oh, this 1 foot is actually an issue. So I called our architect, and she explained it to me. So then I reached back out to her because the landlord had not, Ms. Ahern, had not said any issues. So then I reached back out to her the day before the last hearing and said, hey, this is actually 1 foot in. I just wanted to clarify that for you. But then she never reached back out with all of the concerns. But then on Friday when we got the email, we saw that she had some concerns.
Any other questions for the applicant?
Yes. So it appears from her letter that her desire would be that you scale back. The project be scaled back. I'm not sure exactly what that means, but the right side covered porch be deleted.
So I think when I read her letter, I sort of read it that she might be a little bit confused because she's using the terms right side porch interchangeably. So what is actually encroaching into the setback is a mudroom entrance, and it's encroaching by 1 foot. On the back of the house, behind our fence, so in our backyard, there'll be a porch on that side, but it's not in the setback. And so she's also calling that a porch. So she's calling both of them a porch. To me, the one in the back is a porch. It's not in the setback. The mudroom entrance is more like a side entrance to me. It's 1 foot in the setback. So when she says scale it back, I don't know exactly what she means because she didn't reach out to us directly. But I would assume she means just the entrance. We looked at the staff report and saw that there are other properties similar to ours. We also found another example, also in Westover, 5 foot into the setback, side entrances facing each other. We went to Google Maps and have pictures if you want to see them, but we thought, we agreed with the staff that it would be in conformity with other properties in Westover.
Thank you. Mr. Roll?
I just want to commend the applicant for reaching out to the church. A lot of times people assume, oh, if it's an institution, then, why should we bother? But they're property owners too, and they might be affected. So I think that's commendable. It seems to me that the concerns of the next door neighbor may be the kind of concerns that could be resolved with additional discussion. And so my inclination may be to see if we could give a little bit of time for discussion with the neighbor and see if an accommodation could be reached.
Any other comments? I have two speakers.
I'm sorry.
No worries. Joseph Hayes.
Man, you guys are like marathon. It's awesome. I live at 1016. I was not able to write a letter in support, but I'm full in support of this project. I think that if you're going to have people with families in these smaller homes, it's kind of, you want to have a neighborhood with kids and families, and they got to be able to expand. So, I think that they're fantastic neighbors and, very much in support of the project.
Thank you. Sarah Middlemoser?
Good evening, members of the board. I'm the architect, applicant's agent. Happy to answer any questions about the design. One of the items that the neighbor mentioned in her letter was water issues and runoff. And one reason to keep that 4-foot dimension and keep the areaway foundation was to be able to fill in an existing areaway that has a drain right now that doesn't drain well, creates foundation issues that we felt would be beneficial to fill in rather than demolish. So immediately in the design standpoint, that 4-foot and that existing areaway, we decided to use, fill in rather than demolish. So I'm happy to talk to the neighbor too if that helps explain how water issues, will be alleviated. But as my client mentioned, it really is to help access into the house.
Madam Chair.
Question.
So how does building a porch there help with the water issue?
Right now, it's a stair that actually you enter from the rear forward. There's a drain at the bottom of the areaway and a basement door. We're going to close on the basement door, fill in where the drain is, and then build the porch up so that it's on grade. So right now, it's a hole that goes down into the basement. So it would be mainly to fill in the drain and stop water pouring down into an existing areaway.
So where does the water go with the porch?
Well, next to the porch is a window well, so we're going to keep some of the areaway, create a window well, put a new drain in the window well, that'll be at a higher elevation, and drain it to a sump pump. So I think the goal mostly was to not affect the existing foundation by demolishing a current foundation that ties into it, if that answers the question.
Thank you. Questions, comments?
Construction on projects like this can fray the nerves of nearby neighbors from noise and, other disruption. And it usually goes a lot easier if the neighbors are on board from the beginning. And it can really unravel if the neighbors are the opposite of on board at the beginning. So I don't want to speak for the applicant, but there may be upsides potentially to I know no one likes delays. That's costly and frustrating and so forth, but I really do feel like this reads to me like the kind of thing where discussions could really help put things on the right track at the beginning of the construction project. Do you have any response to that?
Yes, absolutely. So we have always had a good relationship with all of our neighbors, including the tenants. So the tenants are well aware of what we're doing. The landlord mentions an issue with the fence. The tenants are aware of the fence. I mean, our neighbors that live there, the people that are actually residing in that home, are well aware of what's going on. I understand that they didn't want to sign. I talked to them, and they said we're happy for you and all that, but Penny, Miss Ahern, is the one who should
The
sign.
owner, the non-resident owner is the one who has the concern, yes.
So the individuals residing there.
So you don't want her to appeal our decision, for example, right? And so if she's bought into it, she's less likely to appeal the decision. That's an example of how it's potentially beneficial just to try and get her on board with further discussion.
Madam Chair?
Mr. Smith.
I mean, and to that end, well, I can understand your hesitation to agree with a delay.
Second delay.
It's something you don't say, oh yeah, I agree to that. It's unnatural to do that, but I can appreciate that. But there is some merit in that because her concerns, as I'm reading them, are thin, very thin. And she expresses concerns about her quiet enjoyment and, those that a resident, someone who's living there would express, not a landlord.
Mm-hmm.
So I think I would talk to someone like that and try to get them to see it from the tenants don't have a problem with this, and we're not going to be, and we're going to be really, nice with the construction, but she doesn't have it seems like to me, a stake in it, really, other than, she's the owner, the land of the property next door, but isn't affected by your kids going in and out.
They're not that loud.
Huh?
Yeah, they're not that loud.
I mean, it's a mudroom, and the design looks wonderful. I'm sure it's going to be tasteful. It's a side entrance as opposed to a front entrance. It's very common.
Mm-hmm.
I would join with a deferral. I support it as it is. I want you to know I support the application, and staff supports the application. It's, as Mr. Owen is saying, assuaging the concerns of the neighbor who can make life really unpleasant. The owner, I should say, not the neighbor, because they're not a neighbor, they're the owner.
Right.
They could make your life unpleasant. I wouldn't suspect they would because it costs money to litigate, but they might.
And especially if your architect is willing to participate in a conversation like that, oftentimes having a third party who's an expert can help walk them through. So I'm not asking you to buy into this, but I will ask you about your availability at the November meeting. So what's the date of our November meeting? Because I don't want to schedule it for a day that you guys are definitely going to be out of town, because that would be inconvenient for you.
I'd also like to know where this owner is and how easy or difficult it may be to have what hopefully would be a fruitful discussion.
Yep. November 15th, Wednesday, November 15th.
Can you tell me where the owner lives?
I'm sorry?
Where she lives. I'm just wondering how practical it is to have a conversation.
So she lives in the area.
Oh, okay.
I completely understand what you guys are saying, and it makes sense in theory, but We've lived there for 5.5 years, and we've met her once, and we have known all of the tenants that have lived there, and I don't want to speak about her because she's not here, but reading that letter, we tried to reach out to her, multiple emails. She didn't reach back out. She just sent that in. I thought I was sending friendly emails. I was trying to be neighborly with all the other neighbors. Our experience would be that she likely would not come around, even though she may not have a leg to stand on, to use your words. So we would just be deferring it. Again, I understand where you guys are coming from, but realistically, living there for the past 5.5 years, I think that that's what's going to happen. And so, I mean, she got the notice. We expected her to be here. Would have probably been the second time I met her. I don't know why she's not here, but I think, again, that her not being here might be an indication of she might just want to say no for, I don't know.
Ms. Malice.
You know, we can't speculate why she's not here. It may not be a convenient date for her. And I do think that she has a legitimate stake as the owner of the property.
Yes, I agree.
In terms of what happens to it. So if it turns out that your outreach to her is not successful and you report that back to us, then we can evaluate the circumstances as you describe them at that time.
For example, if you sent her an email, you could show us a copy of the email that you sent, right? And then we could see if she didn't respond, then we would know.
I have those emails.
Well, it seems to me that you mentioned as of Friday, this was the first you knew there was an issue, so.
I guess that's my point.
I think I want to differentiate sort of the tenor of this conversation from some that you may have heard earlier in the evening.
Okay.
So earlier in the evening, what we were focused on with some of the applicants is we're not sure that you did enough outreach. That's not a concern that, speaking for myself, that's not a concern at all that I have with you. I think you did above average outreach to your neighbors. So that's in your favor. You had a neighbor who actually came out and supported you, who waited all this time to be there. So that's very much in your favor. And so I don't want you to feel like we're criticizing the job you've already done. However, it's not uncommon for neighbors to come. It's not unheard of. It happens from time to time that neighbors do only speak up at the last minute because that's when they got the letter, that's when they finally read the application, they realized the deadline was coming, whatever, they raised these kinds of concerns. And you've heard several of my colleagues, including me, say the kind of feedback that we're getting from your neighbor is the kind where there has been oftentimes success. And you know your neighbor, and we appreciate that, and I think our view is, at least again, speaking for myself, I'd like to see what happens in the next month and just see this extra round, not because you deserve it because of bad outreach before. To the contrary, you did great outreach before. But just because when we do have a neighbor that is objecting, it's our job to hear out the neighbor and to see if those concerns can be, resolved and understood. And the easiest way to do that is to have the direct conversation between the applicant and the neighbor. And it's much harder and longer when we have to go through point by point and examine with staff, all these things. And so often the less painful, more permanent solution is to give that extra month for discussion. So with that, Madam Chairman, I would move that we defer this item to the November 15th meeting.
I would second.
It's moved by Mr. Owen and seconded by Ms. Malice to defer this application to the November BZA hearing. All those in favor?
Aye.
Aye. Opposed?
I'm going to support that only because there is maximum support for it, but it wouldn't be my inclination to defer, given I think the lack of credibility that the next-door neighbor has said when she says my welfare, when she writes my welfare, health and safety, and quiet enjoyment are being impinged. I think she's really undermined her own credibility in that regard, but I'll agree with the deferral.
And I would agree with your comments too. Thank you. Thank you. See you next month. Next item.
Case number V-11308-17-UP1 is a use permit request by Matt and Katja Bristol, owners, to permit a setback of 7 feet to the wall of a side addition, 5.5 feet to the eave from the adjacent property line instead of 10 feet to the wall and 6 feet to the eave as required, and to reduce the aggregate side yard to 14.7 feet from 18 feet as required regarding the two-story addition to a single-family dwelling in the R6 zoning district on the premise known as 406 North Kensington Street. Staff recommends that the board adopt the attached resolution granting the use permit request with conditions.
Questions for staff?
Madam Chair?
Mr. Owen?
Am I correct in understanding that all of the changes to this, all the encroachments that are being proposed are on the right side of the property? Am I correct in understanding that they would not be visible from the trail?
You are correct that they are all to the north side of the property and would not be visible except maybe a glancing view through the back.
Got it. Okay, thank you.
Thank you. Any other questions? Applicant?
Hi, I'm Matt Bristol, the homeowner. Read the staff report. I appreciate the recommendation. We did solicit feedback from our neighbors who we consider to be potentially affected by this, and that's been included in the packet. I'm here to answer any questions you have and hopefully for your positive review.
Questions for the applicant?
Did you get feedback from your neighbor to the north, 4112 Kensington?
There you go.
Yes, sir. The neighbor to the north, I've lived in the house for 17 years, and it's been a rental property that entire time. So the current tenants are the ones that I did solicit. I went to all the neighbors personally and showed them our plans, and they signed a letter of support.
Got it. Thank you.
Good. Thank you. Other questions, comments?
Madam Chair.
Mr. Owen.
I move that in case number V-11308-17-UP1, I move that the board adopt the resolution granting the use permit with conditions.
Second.
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor?
Aye.
Thank you.
Thank you.
Next case.
Case number V-11309-17-UP1 is a use permit request by Stephen and Alexandra Voigt, the owners, to permit an extension of an existing non-conforming left side setback of 4.6 feet to the wall of a two-story addition on the left side of the house instead of 8 feet as required, with 3.8 feet to the eave, same as existing, instead of 5 feet as required, and to reduce a right side setback to 5 feet from 7.5 feet as existing to the wall of a two-story addition instead of 10 feet as required, with 3.9 feet to the eave instead of 6 feet as required, and to extend an existing non-conforming rear setback of 21.3 feet as existing to the wall of a two-story addition on the right side of the house instead of 25 feet as required, with 20.3 feet to the eave instead of 21 feet as required, and to reduce the aggregate side yard to 7.7 feet from 10.2 feet instead of 21 feet as required regarding a two-story addition to the left and right sides of a single-family dwelling in the R8 zoning district on premise known as 2325 North Utah Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Questions for staff?
Yeah, I have one.
Ms. Malice.
This may precede you, Mr. Rizzi, but on page 2 in the staff analysis, kind of towards the end of the first bullet point in that second section, it says an additional factor in staff's opinion is that staff has received signatures of support from 15 neighbors. And then additionally, one of the neighbors directly adjacent to the left, who's not on the list of the signed statement, met with staff and indicated they were unopposed. I'm wondering if I've ever seen neighborhood support enter into staff's recommendation. Did you find where I'm sorry, did you find where I'm speaking?
here, Stephen.
Yes, I think that in this case, it was just the kind of overwhelming amount of support that we had received from this application that made it noteworthy. It's not something we always include, but nor is the amount of support.
Is it a problem?
It raises a few questions, but nothing that I need to pursue right now.
Any other questions, comments? Applicants?
Hi. Thank you for your time and consideration. I'm Alexandra Voigt, and my husband Steven's behind me. We don't have a lot to add other than just to reiterate what's already in the report. Our house is a 1925 home. We love older homes, and we've lived there more than 14 years. And we love it, and we were hoping to expand it for our family of 5, but stay in line with the architectural style that it has, and sort of in keeping with the neighborhood and some of the older houses that still remain there, which are few.
Questions for the applicant?
Oh, just one more comment, sorry.
Sorry.
We do actually have a signature now from the people in yellow, and I know they'd come in as well as 4 other signatures. They had, that house had turned over late spring, about the time that we were submitting this. I think they moved in July, so we had not wanted to, immediately say hello and then ask them to sign. They're a young couple, just moving in, pregnant. And so, but we've met with them since, and I do have that if you'd like that, and they were very supportive.
Submit that to staff, that'd be great, thank you. Madam Chair, are there speakers on this item? I'm ready to make a comment.
Mr.
Owen. I noted that this site has extreme topography, very, very steep hills, and I think that that is a further mitigation of the impact that would otherwise occur for the proposed application, and so I'm prepared to support it.
Thank you. Thank you.
Madam Chair.
Mr. Owen.
I move that the BZA adopt the attached proposed resolution granting the use permit request with conditions in case V-11309-17-UP-1.
Second. Go ahead. Mr. Smith.
Moved by Mr. Owen, seconded by Mr. Smith. For approval, all in favor?
Aye. Aye.
Thank you.
Madam Chair.
Mr. Owen.
In the next item, V-11311-17-UP1, I have a long time personal acquaintanceship with the applicants, and so I will vote present and not otherwise participate in this application.
Thank you. Next case, please.
Case number V-11311-17-UP-1 is a use permit request by Jonathan Rotter and Lisa O'Donnell, the owners, to reduce a rear setback to 5 feet to the wall of a second-story addition from 5.4 feet to an open deck instead of 25 feet as required, with 4.75 feet to the eave instead of 21 feet as required, regarding a 2-story addition over an existing non-conforming deck in the R6 zoning district on a premise known as 1510 North Herndon Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. An alternative proposed resolution for denial has been provided should the board decide to deny the request.
Thank you. Questions? Okay, I have a speaker slip for the applicant, and I have Mr. Lawson.
Yes, ma'am. Again, for the record, my name is Barnes Lawson, Jr. I represent the applicant. Staff did a good job. I just want to supplement their analysis with some additional historic information. This lot was created in 1927, and that was before the 1938 zoning ordinance. If you look at the plat, you will note that there is a 20-foot building restriction line. That was common back in the days prior to a zoning ordinance. It was a way that the subdividers and the builders created a setback on their own because there was no zoning doing it. So the house was built in 1938, and it seems to have been built under the 38 ordinance. Now, the 38 ordinance required a 25-foot setback for the front yard. And so on this odd-shaped lot, you end up with another 5 feet being added on to the original 5 feet. So now they're back 25 feet when they thought they would start at 20. And the rear yard was 10 feet. And so when this home got built, you can see that it complied. In 1950, the ordinance was changed to make that 25 feet. And that was imposed upon this bizarrely shaped lot, which was created before the 1950 and even the 1938 zoning ordinance. I prepared a chart that I'm going to share with you all, showing the difference between the two zoning ordinances and the impact on this particular lot. And then you can see that it's a big difference. When you're talking about, comparable properties and being similarly situated and so forth, I think what you've got to do is look at other lots that are shaped like this one. And in this part of Lion Village, you'll see that there's only a handful that are shaped even remotely like this one. This is just a very difficult lot to try to do any kind of an addition on. I'm going to hand this out. We have, Mr. Rotter can tell you, but we have statements of support from everybody around us. And I put a little red X on all the properties that they have support. So I'll hand this out while he comes forward and makes a couple comments.
So, thank you, Madam Chair, members of the board, county staff. Thanks for allowing us to speak tonight. I'll be brief since it's late.
Excuse me, would you just state your name for the record?
My name is Jonathan Rotter.
Thank you.
The owner, and I'm here with my wife, Lisa O'Donnell. We own 1510 North Herndon Street. We've been in our Arlington home for about 17 years and residents in the county since 1996. Our family is at a place where we believe we need some additional space. We love our home and its look. We don't have any interest in moving. We don't have any interest in replacing the house. We like to keep it looking like it is, with a little bit of a difference. We have previously done some work on the house, taking the aluminum siding off of it and returning it to the cedar siding that it originally had. We do really love the look of it and the look of the neighboring houses that were built by the same builder. We've been working with an architect, Jim Martin, who is very sensitive and respectful of the style of the builder, Mr. Tuthill. And we're very happy with what he has put together, the drawings that you've seen. So we respectfully request that the board consider and hopefully grant our use permit. Thank you very much.
Thank you. We have one more speaker, Sharon Park.
So Sharon and her husband had to leave. It got a little bit late. She did leave a little written statement, so I can either read it or turn it in or whatever.
You can read it if you wish, sure.
Okay. Good evening. My name is Sharon Park at 3175 Key Boulevard. I'm a registered architect in Virginia and live adjacent to the Rotter property. If you could pull up the site plan, you will see that there are 7 houses on the triangular site. If this were a compliant site planning, no more than 5 houses would meet the setback requirements. All of us are in violation and require variances to add even small additions to our houses. The county should especially be sensitive to this historic condition in approving the modest proposal of the Rotters. They're in a hardship situation without much recourse to bring up the improvement to modern standards. The county should be particularly appreciative that this charming period house will be kept and not torn down.
Thank you. Here, yeah. Thank you. Any questions for Mr. Rotter or Mr. Lawson? Hearing none.
Well, Madam Chair, I don't really have a problem with this, with the additions. So therefore, let's see what happens when I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in V-11311-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor?
Aye.
Aye. Opposed? Present?
Present.
Thank you. Next case, please.
Case number V-11312-17-UP1 is a use permit request by Hugh Robinson, the owner, to permit a side setback of 5.9 feet to the wall of an addition from the adjacent property line instead of 8 feet as required regarding a one-story addition to a single-family dwelling in the R6 zoning district on the premise known as 701 North Frederick Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you. Questions for staff? We hear from the applicant, please.
Good evening. I'm Hugh Robinson. I'm the owner of the house at 701 North Frederick Street. My wife and I have been concerned about aging in place. We've been in contact with any number of organizations that sponsor or encourage such behavior. We have both experienced our parents and other relatives who declined as they aged and were without a bedroom or a bathroom on the first floor of their home, and how difficult it was for them. I also work for the organization Rebuilding Together, which goes out and helps alter homes for people who are indigent or have limited income to make the home safe and healthy. My wife and I also volunteer with a group, it's Tree Stewards, so we're very aware of the fact that trees and other vegetation are factors that are taken into account. When we first decided that we wanted to age in place, our approach was to contact a contractor to determine whether or not it was feasible to do a modest addition to our house by replacing the side porch. We were convinced that was possible. He recommended an architect who we've been dealing with ever since. I contacted the zoning office and got information, picked up the literature, and notified my immediate neighbor, the Kirsches, that we were planning to convert our porch to an addition. And during that process, we were asking for 2 feet beyond our right to make sure we had a wide enough room. Mr. Kirsch initially said that he was concerned about the application process, that it was very involved, to which I replied I didn't think so. He then asked that I provide him with a copy of the architect's design for the addition, which I did. At this point in time, we started talking. He raised the issue of privacy. We have adjoining open side porches. He felt that the addition, being closer to the property line, would affect his privacy, to which I responded, I should think that if there's no longer an open porch facing yours, your privacy is enhanced. Time went by, and I continued to ask him if he would support our proposal, and he would never give me a clear answer. The next response was that he wanted to talk to a real estate agent to find out whether or not it would affect the value of the house. I never heard from him on that regard. I next heard from him by saying he wanted to make sure that his view from his side porch would not be adversely affected by the fact he now had to look at an addition as opposed to an open porch. He raised the issue of having us put a row of trees between the fence line and the house. Being tree stewards, and he had pointed to trees in an adjoining yard, being tree stewards, we realized that that was inconsistent with what we would preach to people who were thinking of putting trees in that space. It would also obliterate our access to the backyard through there. The trees would be supposedly grow to 15 feet. They would block the sun coming in. That's a north-facing side of the house. If there's a diminished wind, it's going to add to the possibility of mold blowing on the house. It would also bar our access to the side of the house for routine maintenance. I offered at that time that we consider raising the fence between the two properties from 4 feet to 6 or 7, or that we put a trellis along the side, along the fence line to soften the view. I did not hear from him. On August 26, 5 months after I first contacted him, he gave me a letter, which you have in the file, proposing that, in fact, the row of trees be placed there, which he knew we were already objecting to. Again, my wife and I discussed it. We met with the Hirsches. We again appealed to them to respect our proposal. And we again raised the issue of if they wanted the low row of trees, that they place them on their side of the fence. That would be their responsibility to maintain them. They consider having a trellis put up.
Could you just sum up, please?
Sorry?
Would you sum up?
My summing up is we believe we have a valid request to permit us to age in place. It has been designed by an architect and it looks good to us. And we have reached out over the 6 months since we first made the announcement to our neighbor that we had options that we thought would suit their purposes, and he has not responded to them. And if I may just add, following the last meeting that was deferred, the following morning he saw me in the front of the house and he said, "Oh, there may be a silver lining to having the meeting deferred," which I took to mean that he would consider other options for providing him this visual improvement. And I reminded him that I had proposed putting the tree line on his side of the porch, on side of the line. We consider a trellis, or we consider raising the fence, and I also suggested if he had another idea, I would be happy to entertain it. I have not seen or heard from him since that day.
Thank you. Any questions for the applicant? Okay, I have 2 speakers. Stephen Kirsch.
My name is Stephen Kirsch. I live at 705 North Frederick Street with my wife, Deborah. We respectfully oppose this request and disagree with the staff due to the fact that the proposed addition will harm the view, open feel, amount of light and air and privacy of our screen porch directly across the property line, especially when there are other reasonable options that Mr. Robinson has that do not require an exception. The exhibits that I passed out show that the instances cited by the staff in supporting this recommendation actually are not compatible with what Mr. Robinson wants to do because none of the other properties used as examples by the staff assessing compatibility involve a side yard setback directly across from a neighbor's open frame screen porch. 713 and 717 North Frederick Streets are about putting garages at the end of a driveway. 720 North Emerson Street has no porch next to the addition. Neither does the other one on 717 North Emerson Street. And the property directly across the street at 700 North Frederick Street in 1962, a variance was granted, but there's no screen porch visible on either property to their right or left. So those actually do not support what the staff said. In addition to that, the fourth criteria for approving a use permit is that it must not conflict with the zoning-related policies of the county. But Section 3.2.1 of the zoning ordinance says virtually every land use requires an appropriate relationship between the lot area, intensity of use, and sufficient open space surrounding such use to secure safety from fire, to ensure privacy, to provide adequate light and air, and to conserve the value. That will not happen here. It's also completely unnecessary because this is a 264 square foot addition that could be built in the backyard as set forth in our letter without requiring any exception whatsoever. There's a door from the kitchen that could access this addition if it were built in the backyard. It would not require any demolition of the walls or changes to the property. Thank you very much.
Deborah Kirsch.
Hi, my name is Deborah Kirsch. I'm the property adjacent to to Mr. Robinson and his request to build in. So my husband and I, we work very hard and we've very diligently saved for many, many years in order to purchase our home, and it's the most significant financial investment in our lives, and therefore we're very cautious about making any decisions that will impact the value of our home. And as the property most impacted by this proposal, we felt compelled to look at the full proposal in depth before offering an opinion. These renovations next door to us have been a frequent topic of discussion in our home. We've debated all the pros and cons of the situation, including our relationship with the neighbors. It's reasonable to want a bathroom on the main floor, and I support building as needed to allow for that in conformance with the established setback requirements. Exemptions from the county ordinances concern me, as these laws are written to protect the interests and the safety of all parties. And it's also reasonable as a homeowner to expect that these zoning laws will in fact be enforced. One of the reasons we chose a single-family home on the street is that it included open space on all sides of the home. As my husband outlined in more detail, no other property has a non-conforming structure that faces their screened-in porch to limit that open, natural feel of an outdoor living space. Building closer to our home also is a safety concern. 2 years ago, a neighbor's shed caught on fire. Not only was their home damaged, but Mr. Robinson, who lives next door to that shed, suffered damage to his property as well. So for me, that was the first time I experienced a fire in my neighborhood, and it was quite humbling to realize how fast those flames can spread from one property to another. Like I said, my husband and I discussed this a lot, and after careful consideration, we decided it was best to try to work with Mr. Robinson to see if a compromise could be made. We suggested the trees be planted to build a screen. Instead, he countered with a proposal. So it's certainly not our desire to have bad relationships with them. Mr. Robinson said if we were opposed, he would prefer our silence. But I felt it was important to participate in this process when I feel that there's a change being made impacting my property. So thank you very much for your time.
Thank you.
Madam Chair.
Mr. Owen.
I'm wondering if the person, I'm sorry, ma'am, you were just speaking, I have a question. Sure. I think you were about to address the other offers that Mr. Robinson made to you.
Yes.
Can you discuss your reaction to those? And he mentioned several of them tonight. Can you talk about those?
Yeah, so the original proposal that we had planned is for them to plant trees on their yard to just give us kind of that natural feel once again. He had, casually thrown out the idea of maybe planting a trellis, with greenery. We did look into that. In fact, it requires a variance to build a trellis above a certain size, which was kind of the screening level we were looking for, would be one that required a variance. We didn't think that was a good solution to cause another variance. And then he also proposed just building a higher fence, splitting the cost, which that to me, still doesn't screen it. It doesn't create the open feel, so it was not really addressing my concerns of taking away the nature feel by bringing a solid wall and now a taller fence closer to our home and our property.
Can I just follow? May I follow?
Ms. Malice.
So the only acceptable option to you of the ones that you've been offered is a natural barrier.
That we've come up with. We thought about other options. As I said, we discussed this, like maybe they did, 2 smaller trellises, one on their side, one on our side. One of our concerns with a landscaping solution would be, eventually the property will turn over. So landscaping on their end may not be honored by a future owner. They suggested, why don't we plant the trees at our side at our own cost, and that didn't feel right to we're obviously free to landscape our property at our own cost as we wish, so that didn't seem like a compromise.
I'm trying to
position.
establish, so what would be acceptable to you?
Some perhaps assistance with changing the landscaping on our, financial assistance with the changing the landscaping on our side.
And
version of a smaller trellis. I mean, we're really...
So these are things that we can't work out sitting here, you understand, figuring out how big the trellis ought to be. Is this something that you can discuss with your neighbor to work out exactly what you are looking for here?
I mean, we certainly can try. I think we've unfortunately been troubled with a lot of communication problems where we just can't seem to hear what the other person is trying to say. I know after our conversations, I feel I was not heard, and I'm sure if you ask them, they probably exactly feel the same way of our discussions haven't been effective and everybody leaves feeling unheard, which is how we ended up here tonight. And I think we had an agreement on the feeling unheard after a discussion.
So is it possible to have a conversation where you each feel heard and can come back to us with an acceptable solution?
Yeah, I mean, I'd be certainly willing to give it another go.
Okay.
Madam Chair.
Mr. Smith.
When looking at the packet, there's a piece of paper that's called an agreement. It looks like it was authored by Mr. Robinson, and it's on a couple different things. You've seen this, right?
That's mine, actually.
Oh, you created this?
I created that.
Okay.
This is Steve Kirsch.
All right.
That was our tree proposal.
Right, exactly.
Plant trees, and that would be adopted as a condition.
Isn't that what I just heard a discussion about by your wife?
That was some of it, yes.
Did she say yes?
That was our proposal.
No, we
would
asked
accept
them
that.
to plant trees, and they said
Okay.
no.
So, Madam Chair, might I ask the applicant what their reaction is to this agreement document?
Mr. Smith, when that was presented to me over my back fence, it was in an envelope.
Okay.
They had approached me, I was working my back.
Letter.
No, just that document. We had discussed that proposal. There is if you could look at their house, I believe it's number 700 on North Emerson Street. Along the back fence of that property are these tall trees, or shrubs, trees, I guess, which they pointed out to me as they would like to have planted on our side of the fence line. And again, being a tree steward, we would never recommend to a homeowner planting trees in that narrow space, given the considerations. So out of hand, I would have had to be violating my own philosophy to agree to that. I had no objection. I suggested, if that's what you're concerned, put them on your side of the fence. The other proposal was, I don't know if you can see it there, but we have a trellis.
Well, I'm not playing, Madam Chair, if I might, I'm not playing mediator, but what if there was a case earlier where we actually had an applicant to assuage the concerns of their neighbor, paid them to do landscaping of their choice?
I would pay for them to put those trees on their side of the property line.
That was, okay. I don't have any further questions.
I would pay to have the fence raised, share this price of raising the fence. The original fence was put in with the knowledge of the previous owners, and we shared the price.
Okay.
I heard him talking about your neighbors, the Kirsch's, talking about trees, and I now gotten to the bottom of who authored this. They did. It seems to be close in terms of where it might resolve. I don't know if more time, another month, might resolve this. I know you have plans to try to make your home accommodating on the first floor to age in place. I can understand that 100%. moved into a condo. But maybe another month, we would be able to bring some closure to this in terms of the difference of opinion, like we did in that earlier case earlier this evening. I don't know.
And I think
up to
it's
really my
yeah, but I think it's important to understand that this is not the forum for us to work out your differences. But we'd like to resolve the case. So if it's possible that in the ensuing month, if we deferred to November, you all could actually meet face to face and come to some understanding.
I would hope so. I actually thought that was going to take place after the previous meeting when they suggested that there was a ray of light.
It seems clear that we're not there yet.
That's correct.
Thank you.
Madam Chair, I have my colleagues go along with this. I'd move to defer this matter V-11312-17-UP1 to the November meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Mr. Owen. Mr. Owen.
May I comment? Oh.
By all means, Ms. Malice. I defer to Ms. Malice.
Mr. Owen.
Madam Chair, thank you. I would just say that I find this a very difficult case. To me, it's right on the edge. I think, on the one hand, my view is that this is not, this request is not very different from what I see in the rest of the street. You know, it's, I appreciate that they're not porches to porch, but in terms of the general character of the street, I see that it's, it does seem compatible, but at the same time, I think it's a very close question to me as to whether or not there's a reasonable assessment that it injures the property value of your neighbors. That I think a lot of people in their position might think, if they were thinking of buying the house, if they were thinking of living in the house, that they might think that additional having windows or whatever closer to them, or even just chewing up the yard, you know, next door, is getting close into the area of injurious. And so I really don't know how I would vote either way. And it would be so much better if you guys were able to figure out something that made everyone a little bit better satisfied, because if that doesn't happen, then someone's going to lose. Either you're going to lose or you're going to lose just outright. And I think it's just a better outcome when people can not lose all the way. So that's just my comment. I still don't know how I'm going to come out on this, but I hope that I don't have to make a stark decision, because then someone has to lose all the way, and that would be regrettable.
Ms. Malice?
Mr. Owen spoke what was on my mind. When it comes back to us, we'll have to, if there is no agreement between the parties, we will have to rule one way or the other. It's certainly to both of your advantages to take that uncertainty out of the equation and decide something that you can both live with. But, you know, it's just going to, I know it's hard when feelings and, you know, things have gone back and forth for a long time. But you're neighbors, and hopefully this will set the tone for a better relationship down the road.
Okay, we have a motion to defer to the November meeting. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11313-17-UP1 is a use permit request by Soria Turner, the owner, to permit a side setback of 0.67 feet to the eave of an accessory structure from the left side property line instead of 1 foot as required, and to permit a setback of 1 foot to the wall of an accessory structure instead of 10 feet as required regarding the placement of a 190 square foot, 1-story accessory structure on a corner lot in the R5 zoning district on the premise known as 838 20th Street South. Staff recommends that the board adopt the attached resolution granting the use permit request with conditions. I'd also like to note that there is considerable supplemental material for this case that came in after the application packet was assembled and printed.
Thank you. Questions for staff? Applicant, please.
Good evening. Clearly, I'm not Soraya. My wife, Lieutenant Colonel Turner, is currently in Texas for training, pre-command course, before she takes over at Fort Myer at the clinic there. I am Michael Goddard, her husband, representing her this evening, and she even wrote something for me to read to you right now, so I'll go ahead and do that. We bought our home at the end of November 2015. It's been a rental house that was in serious disrepair, her words. I would concur. We've spent the last year and a half renovating every room while doing everything we can to preserve the home's original charm. We had our front yard professionally landscaped that is perhaps not represented in that overhead shot. That might be a little old. To continue forward, we would like to build a quality-looking shed. That's all the accessory building is a shed in the back. And finish out the landscaping in the rear once that construction is completed. I believe you did have some shots of what it looks like currently. It is not pretty. There's hard-packed earth, gravel, and some odd shredded rubber. This is all what was on hand when we bought the house, and we are looking to improve it. We contacted our 3 immediate neighbors that we thought would have the most, well, I guess the most most input, and we did not get a response from Yvette Bommersheim, which is our direct neighbor, but on the other side of that common access alleyway, we talked to Dave Littman and his wife. We have their support as well as Thomas Ukrit across the street. There's not much else to say that's not in that report. At this time, I would like to take any questions from the board.
Questions?
We'll wait for the speakers.
Madam Chair, I do have a question. Did you say you had support from Ukrit?
Yes, Thomas?
Of 920th Street?
Yes, sir.
Because we got a letter that says, after hearing more details about the property and considering the eyesore this property represents to the line of sight for my property, I want to express my disapproval of this exception to the zoning for the corner lot at 838
Okay.
20th Street.
I was not aware of that.
Not in keeping with the other duplex lots, which it will abut and will be much higher than the fence that currently exists there. I believe this development would have a negative effect on the value of my property should an exception be granted to the proposed home gym.
Okay.
That's at variance with what you said. He may have changed his mind, obviously.
He did.
He did, because we also have his signature and approval in the packet. So he changed his mind.
There's a shed on our next door neighbor's lot, right next to where we're going to put ours. So that's odd.
Thank you. We have 5 speakers. William Bummersheim.
Hi, good evening. Thanks for having me. My name is William Bomersheim. I'm the owner of the house that's attached to the applicant's house. My wife and I oppose the application for the variance. The proposed structure is too large for the property in question. I understand that it's 20 feet by 30 feet. There's only 34 feet between the house and the alleyway. The variance would allow construction right next to my property, excuse me, right next to my property line. After buying and moving into the house in 1997, we created outdoor space. We put in a patio, gas grill, beauty bar. We planted flowers. We did put in a shed. The shed we put in is 8 by 10. It didn't require a variance. The building and the neighbors right next to us, the building that they're proposing would go right on the lot. It would be a wall that immediately puts the entire backyard into a shadow. I also fear, or we fear, my wife and I fear, that the building would damage the 78-year-old oak tree that's in our yard and the 78-year-old oak tree that's in their yard. We hired an arborist from RTEC Tree Care. in 2015 to trim and give us recommendations on the health of the tree. Who's going to pay if a few years down the line the tree is damaged and we have concerns that the digging that's involved, they're talking about 2 feet digging and just a few feet from the tree. I don't think the picture really shows the tree that's there. These trees are immensely valuable to our properties and to the county. And thanks for having me.
Thank you.
Madam Chair.
Mr. Owen.
I have a question for the speaker. Do you see the picture up now?
Yeah, so that picture is of the neighboring lot, not of my lot.
Oh, I see. Oh, you're worried. Got it. So on the right-hand side,
their tree is in the picture. We have a tree that's very similar that's in the next door. I'm not sure exactly how they fit this structure in without cutting down the tree, but they have to put it right next to the tree.
Is on the right-hand side, does that show your tree behind the fence?
No, our tree can't be seen from this view.
Okay, thank you.
But if you look on this view, I think the street is on the right-hand side.
Mm-hmm.
Well, actually, you've got 2 different pictures.
Right, and so I'm asking on the picture, the second picture on the right-hand side with the trash can in it?
Oh, yeah, you can see the tree on the other side of the fence if you're looking at that.
And so that's the tree that's on your property, and you're concerned about damage to that tree?
Yes.
Okay, thank you.
Lydia Biot.
Thank you. My name is Lydia Bayud. My husband and I are Bill Bommersheim's tenants at 836 20th Street South, and we've lived there for more than 2 years and intend to stay. We share the other half of the duplex with the applicants. I oppose the use permit application because the site and proposed home gym construction, as listed in the architectural drawings, are incompatible and incomparable with the other homes in the area. We and our neighbors, who are also here, have the only 2 duplexes in the surrounding blocks. Part of these duplexes' charm is their small size, but here, the photos and paperwork seem intended to convince you that the applicant's property is most similar to standalone houses with large yards that can accommodate sheds or accessory dwellings. The application also omits images of the sites most similar to them, which are also the most impacted by this construction, our duplexes. Constructing a 14-foot building with a 2-foot foundation will immediately and irrevocably have a negative impact on our and our neighbors' homes, as well as the 2 towering oak trees in our backyards and the thriving animal ecosystem that lives in those trees for reasons that we've extensively laid out in our letters. Lastly, although the application was submitted in July, the applicants have never spoken to us about their plans, but for the efforts of our neighbors to investigate this application, we would have remained in the dark until construction crews showed up. I ask you to please deny this request. It will overwhelm the lot and is not an appropriate size for these dwellings, which are different from every other dwelling in the area. Barring a denial, I ask you to please delay decision-making until you've had time to review the substantial record we and our neighbors have submitted in the past several days, including from one of the neighbors who originally supported the application but recanted and now opposes construction after they saw the architectural drawings and had more information. Thank you for your time and at this late hour, and thank you for taking my plea into consideration.
Thank you. Con Beyond.
Good evening, ladies and gentlemen of the board. We thank you so much for this opportunity. I would like to specifically thank you for the stopgap that the board member mentioned. Had it not been for the stopgap, we would have not known that this was happening. My name is Count Bayud. I live next door to the applicants. We shared a duplex for the last 2.5 years. I strongly oppose this application for the following reason. The application specifically asks the board to carve out an exception to the laws, rules, and regulations of the county to build what seems to be an industrial-grade addition, more like a warehouse due to its height, large design. The county codes, ordinances, and regulations are here for a reason. That reason is to preserve and maintain the welfare, the health of the residents, their safety, quality of life, and most importantly, the environment, which affects all of the above. Allowing this construction to move forward would set a dangerous precedent and create a laissez-faire attitude that would severely impact collective morale of the residents and the neighborhood by giving the impression that the county rules are a simple formality that could be easily circumvented. In this particular case, the totality of circumstances statement by the general contractor who said they want to build a home gym and receive clients, and the use of their basement for B&B purposes, commercial use, applicants being a professional trainer himself, we submitted attachments with his website, and the blueprint from their architect that states this is a home gym, and the large size and unusually high addition leads us to believe this would be a commercial use. Sheds are readily available at a fraction of the cost at home improvement stores. Unless the applicants here intend to have a return on their investment, there is no reason for them to spend this much money to dig and build such a high tent just for a general use shed, which in their statements contradicts what the blueprint said. Allowing this to move forward will irreversibly impact the quality of life, certainly impact the massive 80-year-old trees that are shedding that are shedding like good environmental microcosm in our neighborhood.
Thank you.
Thank you.
Mary Penchoff.
My name is Mary Penchoff. I live at 832 South 20th Street, which is the fourth duplex in a row of 4. If you had all the facts in this case, the staff would never have approved this, and so I was very shocked by that. I've lived there for 23 years, and the photos of comparables are very misleading and are nothing like what is being proposed. None of them are as large and on as small of a lot as what is being proposed and would have this kind of impact on their neighbors. This is the largest home gym built as an accessory dwelling of anything in the neighborhood in height and size. It's not labeled as a shed and would be the biggest, tallest building on the smallest lot in the neighborhood. If approved, the other duplexes could build structures this large and thereby create eyesores and substantially bring down property values. Currently, only 15% of buyers will buy a duplex property precisely because of the potential problem like what is being proposed. A neighborhood realtor, Jiva Lester, said the sheer size and height would make it an eyesore and detract from the values of the other duplexes. The county's comparables are all garages on large lots. They are not home gyms. They are nothing like what is being proposed with large amount of green space on their properties. Until the notices were posted on the poles in the neighborhood, I had no idea anything was being proposed. The people proposing this project purposely did not tell any of the adjoining duplex properties of their plans. They purposely went to 2 other neighbors for letters of support, not the neighbors most directly affected by their project, and did not inform those who were most affected. When I talked with one of the 2 neighbors who submitted a letter of support and showed him the drawings of the size of what is being proposed, he recanted his letter of support. I have a new letter showing his opposition to this home gym.
Thank you. Carlton Sanders.
Good evening. My name is Carlton Saunders, and I am the owner and active resident of 834 20th Street South. So I abut Mr. Bummersheim's property. I have been there, as I say, nearly 20 years myself. Stephen, I want to thank you, first of all, for downloading the pictures. Has the board had a chance to look at those, and did they turn out clearly? Because I think that's very important as far as what we're talking about with the difference between sheds and this kind of structure, which really, according to the architectural print, is a home gym, which is very different from the structures that have been built. Moreover, it's like a poker game here. I've got pictures if you want to look at them. But it does show on the properties that I showed, they are on huge lots where these, for instance, on 839 20th Street, I don't know if you have those in front of you, it shows the relative size of the shed, and it's almost just in a little corner. This shed is going to take up nearly the entire property of the backyard, as my my previous speaker said. And not only that, I'm telling you as an owner, 18 years ago when I bought, one of the main tenants for me to buy were the trees. You know, that kind of neighborhood cannot be duplicated. And you have some of the oldest trees in Mr. Bummersheim's and 838's property. And I mean that. So I'm just hoping that the board decides, for a number of reasons, along with what my previous speaker said, that this is entirely wrong. Thank you.
Thank you. That's the last speaker.
That's the last one.
Madam Chair?
Ms. Malice.
Question for staff. Is there a by right option on this shed?
Yes, the applicants have an ability to do an accessory structure. It would need to be 10 feet off the rear property line and 1 foot off the adjacent property line and 8 feet off of the existing structure.
You don't happen to have a rough calculation of how large that would be? Or maybe you
Smaller than the current structure, but possibly larger than the adjacent structure of 80 square feet.
And the by right location could be built on the side of the tree?
Yes.
Okay.
Other comments or questions?
What's the required setback from Ives Street for an accessory structure?
Yeah. Checking.
Okay. Well, let me put it this way. There was no requirement for the proposed structure to encroach into the street right-of-way limits, right? I'm sorry, that was poorly stated. There's often something like a 25-foot setback requirement from a street, and you were checking to see if that's the case here. But this application is not needing or requesting an encroachment into whatever setback requirement might exist from Ives Street. Is that right?
It's not currently requesting it. It may require it, though. Once I have that answer, I'll let you know.
It looks like there's a drawing in our packet that has the color lines that suggests a 33.4-foot distance between the house and the back property line. So if you take 10 feet from the rear and 8 feet from the building, it looks like the by right could be 15 feet long. Does that sound about right?
Sounds right.
So for the width, it would depend on, it would be 1 foot from the property line and then perhaps some distance back from the street, which is what you were researching. So I think it may not be possible to build where the tree is, because that might be closer to the street than would be allowed to have a building or a structure.
But that was not taken into account in this application, correct?
The distance from Ives Street?
Yeah.
I don't know. I can't tell whether the staff took that into account or not.
It's right up against the...
Well, 15, 6, 3 1/4. That's what he's proposing.
It's going this way, so Ives shouldn't be
So
affected.
it would be,
Generally, there's a 25-foot setback from a street.
Usually.
That's what we deal with corner lots all the time.
This is R5, right? That's not an unusual.
Right, and so it looks like with some some relief from the side yard setback, if that's a requirement, that you could have a smaller shed by right in that corner. It would be, but it's supposed to be 10 feet off the rear property line, 8 feet from the house.
So it's got to be right in the
So
middle.
it's going to be kind of right toward the front of where it is. But there's a by right option. There it is.
Yep.
And it seems like it wouldn't impact that tree.
It's 25 from the street right away.
Well, who knows where the roots go, right?
Well, certainly the roots. I mean, you're not gonna, anything you do back there, yeah, because they're proposing it looks like a 2-foot deep foundation. Because when you do that clean and jerk and release those weights, you can't have it bounce off of wood.
I've been informed that the setback from Ives Street would be 25 feet, which would mean that it would not have a by right.
There's no by right option.
It's a 26.5
Property.
foot wide property.
So why isn't the Ives Street setback relief part of this application?
I'd say that's an oversight.
All right.
So we can't act on this application regardless of.
As advertised.
As advertised.
And I'm sorry, so that means that did we just establish, while I was focused on that question, that there's actually is not perhaps a by right option because it's all within the 25 foot? I'm prepared to move for denial.
It seems like.
Or, Madam Chair, if I might, I'm sorry, Ms. Malice, maybe Mr. Owen would entertain a deferral for 2 months to allow him to bring forward new plans that might be smaller in scale and.
I don't want to pull this through our docket for that discussion. I think that they're going to have to come up probably for anything that I would be interested in approving. I think they would have to come up with something completely different.
Oh, yeah.
And so I think a fresh application that has all the time in the world to talk with neighbors, from my perspective, is.
If they were given the opportunity to withdraw, they might save some money. We just deny it. They don't get the opportunity. They could write out a quick withdrawal right now and submit it and perhaps get some of their filing fee.
Is that true?
I didn't hear the question. I'm sorry.
Do they get a filing fee reduction if they withdraw?
In
as
writing
opposed to getting a denial?
We've already advertised, and it's already, I mean, it generally has to be withdrawn before we act on it, but I can check.
Well, I mean, the Demura case, the Yogi Demura, we did just that. We accepted a withdrawal in writing so that they could they were promised, at least by the county staff, that they would receive some refund, some portion of a refund of their a filing fee if they withdrew in writing prior to, I think it's an action, but in any event, they were given that. I'm just wondering if the same would hold for this applicant if they withdrew right now as opposed to being denied and then losing the full fee. What was it?
It's 50% prior to review.
Well, I would just hope that we treat this applicant the same as any others that have gone before us.
So, well, if we're looking that up, I'll just say I'm completely persuaded by the neighbor's case that this does not meet the statutory definition, leaving aside the fact that it was misadvertised, I mean, which apparently it was. That's not a fact. That's not necessary for where I stand on this. I think it is one of the more obvious cases that I've seen on the BZA for not meeting the statutory criteria for a use permit. And so my reluctance is that we've seen in many cases even tonight where we've asked people to go back and talk because it was close.
Right.
And so they might get something that was close. And I don't want to give false hope to the applicant that they're close, because they're very, very far.
Yes.
They're so far that we didn't even realize how illegal it was before the meeting started, right? But even that, they were still far. And so I don't want to, we have not, but I guess you're just one of the two homeowners. The other one's not here. I can just imagine the conversation, well, but, what really happened? And so I just want to send a very clear message that this really needs, if anything might happen, which I even think the might is perhaps too much of a hope, really starting over from square one in terms of their thinking is the more appropriate signal to send.
Madam Chair, I'm with Mr. Owen 100%. I'm just looking for a way for them to save if they desire $178, $9, if they would get 50% back, like the Yogi Demira bed and breakfast that didn't get to the county and had been before us and then was deferred for a long time so that they could go before the county board for the purpose of trying to get a site plan, trying to get a zoning change for their property. And I think they were offered the 50% for withdrawal. I'm just saying, if that's available, I would like the applicant to receive the benefit of that. If they would even accept it, they might say, well, I prefer to go take my chances and see if Mr. Owen is right. He's got 3 votes tonight. He's got 2 because he's got mine. I'm not voting for this. So I'm wondering whether they can get anything back if they were to withdraw.
The ordinance says 50% of the filing fees can be refunded upon written withdrawal, but it has to be before commencement of review. So we've obviously already reviewed this and it's been presented.
I think it's too late.
Well, but
I can't speak to what happened with Yogi. I don't know how that was disposed of. I know, but I didn't personally handle a withdrawal.
You didn't see the writing? There's an email.
No, I don't remember.
I'm sure.
Mr. Owen.
Do we have an alternate resolution for this one? No. Madam Chair, in case V-11313-17-UP-1, I move that the BZA deny the application.
Is there a second?
Second.
It's been moved by Mr. Owen, seconded by Ms. Malice to deny this application.
Just for the record, I'm going to vote no on this because I would offer the applicant an opportunity to withdraw and take his chances on making an application for return of his fee. That's what I would.
I would do that too, but I don't get our zoning administrator saying that's not an option.
But I heard that, but also we treated one case, Mr. Yogi Demira's case, the bed and breakfast on Pershing, in one way. He was said specifically, if you withdraw in writing, you can get 50% back.
We also didn't have a public hearing for that case.
We had a hearing months ago.
It was deferred every month. We never actually heard it or acted on it.
We didn't act on it, but we got, other than defer.
There was no testimony, and I don't think there was ever a recommendation other than a deferral.
Is that the definition of review?
Yeah, see, I don't.
I just wouldn't say that there's parity between the two requests.
I'm almost certain there was testimony on the record in that case. We looked at it. We reviewed. I know we heard a staff report on that.
Does anyone in the county have the discretion?
The board.
The county board does.
I don't set the fees. The board sets the fees, and I have
by case basis. Does the manager have the discretion?
The refunds that are allowed are spelled out in the ordinance.
The ordinance.
Yes.
Madam Chair, I would certainly, since the applicant met with staff and staff has led them down this path to the point of actually supporting their application, I think that that would be a fair outcome.
Well, I would ask Mr. Owen if he would, and Ms. Malice, if they would withdraw their motion and allow me to offer a motion to ask the applicant to withdraw, or if the applicant would
Okay. I
be
mean,
so disposed.
it's just,
And see where that goes.
it's just pending. You can ask while it's pending.
Right.
So go ahead and ask if you want. I don't mind.
Would you consider, you've heard this discussion, you're not going to get an approval. You could get denial. You may have an opportunity to get some refund of a part of the filing fee. You can make the argument that other cases have been. But at the very least, it wouldn't be any different than it would be better than a denial. Even though
Without
denial, you
prejudice.
could appeal and go to the circuit court. I'm not going to say how they would rule, but I don't think that you'd be met with very much success. But a withdrawal, I think, puts you in a slightly better position. Certainly with your neighbors, you could say you heard them and you're going to talk to them about what might be possible there. That's where I am, Mr. Owen and Ms. Malice. I would just give them that opportunity versus.
I haven't heard the applicant's response on the record to your question.
Yes. What is your response?
Certainly, we can go with withdrawal. Could I quickly respond to a couple things that were in error? It is not 20 by 30, it's 190 square feet total. And those are footers, not a slab for a 2 feet dig. And a footer is just the responsible thing with any type of concrete structure. But everything else would be on grade. And there's no intention ever to touch those trees. They are also county trees. We'd have to ask before we could even touch them. That's all I would say.
Madam Chair, just another question, and it is, because I heard Goddard at the beginning. What is your relationship to Soraya Turner?
We were married in May, and
Okay.
paperwork takes a long time.
That's okay. That just clarified it. That's your
Correct.
your
Yes,
wife.
sir.
You just
And I believe Mr. Owen is correct about the 25 feet. So yeah, 6 inches by maybe 10 feet would be my appropriate shed by right, and I can't do much with that.
Right.
But to answer your question, yes, withdraw.
I'm willing to withdraw the motion if that paves the way for a withdrawal.
Well, I move to accept the.
Got to ask Mr. Owen.
I ask unanimous consent to vitiate the motion now pending.
Second.
Unanimous consent?
Objection.
No objection.
Could you repeat your motion?
The motion I made was for denial, and then I made a unanimous consent request to vitiate the motion, to delete the motion. And it appears there was no objection. Is that right, Madam Chair?
I move to accept the applicant's withdrawal of the case V-11313-17-UP1.
Second.
Mr. Smith has moved and Mr. Owen has seconded. Motion to accept the applicant's withdrawal. All those in favor?
Aye.
Aye. Thank you.
Mr. Goddard, your wife will have the benefit of a recording. She'll be able to hear it, so you won't have to convey what happened. You can just press play, and she can hear the painfulness of it that you experienced firsthand.
Madam Chair?
Thank you. Yes.
I think other than the minutes, that was our last item. Is that
Yes.
right? I would be interested in making a few comments that don't relate to any particular item at a time of your choosing.
Go ahead.
I'm really so super excited about these new graphics that show the blue and red neighbor support and opposition, and so I just really want to, again, express my appreciation for that. I didn't want to delay everyone while Ms. Malice was raising her concern about that. I can't remember the address, but that addition on the hilltop where the staff had said 15 neighbors are in support. I don't think that was an appropriate analysis element by staff. The way we weigh neighbor comments is very specialized, but I think we rely on staff to give us a recommendation that doesn't take into consideration political factors. Neighbors can bring facts to the attention of staff or the BZA, and that's fine. But the fact of the support is, I feel like it's dangerous territory for non-political staff to weigh in. So I just wanted to weigh in that seemed unusual to me as well, but I didn't want to emphasize it this way at the time in front of everyone. Yeah, I think that was it. Those are my 2 comments.
Any other comments before we go to the minutes? With respect to the minutes, on page 6, even though they're not numbered, it seems to be toward the top of the page, a completely out of place
Yes.
narrative that seems to go with
The previous
the
item.
fence.
Yep.
296.17.
Paragraph really goes with the previous item.
Yeah.
Madam Chair, I noticed that as I was flipping through, I didn't actually have a chance to review the minutes myself before tonight's meeting because I was, as we all were, I'm sure, cramming in 2 nights of work over the weekend. I wonder if maybe we should defer the minutes to Wednesday's meeting so that we can take a little more time with it.
Yes, and this is August, and we've been deferring them because they seem to have been cursed, these minutes. They don't seem to be capable of coming out making any sense. So yes, let's just agree to not address them until next time or whenever they're ready.
You mean Wednesday?
No, I mean November.
Okay.
Oh, November.
It's like, well, I mean, that's okay with me if it's Wednesday, as long as you can get it.
No, I'm fine.
it out
I'm
by
fine
then.
with November. This is a tiring week. Why add to our workload?
Okay.
We should make a motion to defer the August 9th BZA minutes to the November hearing.
Second.
Okay, so moved and seconded. We're deferring the minutes to November, the August minutes till November. Thank you. Can we adjourn, please?
Aye.
Move to adjourn.
Well, I'm sorry, what was the vote on that motion?
4-0.
Okay. I move to adjourn.
Second.
Thank you. See you in 48 hours, in less than 48 hours.
You love us.